Good morning. The time is 9:01. My name is Christian Waugh, and I hereby call the Citrus County Code Compliance hearing for December 2022 to order. We have an agenda for these hearings, and so the first item is, as you might imagine, the call to order. The second item is the pledge to the flag, so I'd like to ask you to join me in that. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning. If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
And the next item on the agenda is approving the minutes from November 16th, 2022, which is basically a record of the last hearing. And I have a copy in front of me. I have reviewed it prior to this hearing. Are there any objections to the minutes as currently formulated?
No.
Okay. Then without objection, I approve them.
Staff update: abated and continued cases are listed out front.
Okay. All right. So again, everybody, good morning. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing today. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation and allow the county to present its case. You will then have an opportunity to present your case regarding the violation, which may include evidence if you wish. During this process, the county attorney's office or myself may have questions of the parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak in each case, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and be made as succinctly as possible. This is not an appropriate forum for personal attacks. I'll also note that there are a lot of cases set for today, so it may be that we have to ask for your patience until your case is called. Feel free to take bathroom breaks as you need. In most instances, if you are found guilty of a violation, the law requires that you be given time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all the property that you own, and the county may foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county law. In all cases in which I find someone guilty of a violation, I will impose all costs required by county law. If you fix the violation in the time allotted, that cost will remain minimal. If you do not timely fix the violation, you'll be responsible for additional costs, as well as the cost of imposing the lien itself. If I find you guilty of a violation and allow for a continuance of your case, you'll be required to return on a certain date. In the time between hearings, I will require that you comply with the county and its codes in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each day of the violation from today's date forward. Your failure to return on the next date may be deemed evidence of your failure to cooperate with the county. Are there any appeals of orders to demolish?
No.
Okay. Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you very much.
The first 3 cases on the agenda, Ernest C. Drake and Valerie M. Drake, case numbers 217-0204, 217-0205, and 217-0682. Code Officer J.C. Charlton, pages 12, 13, and 14 of your agenda. The Experts on the case will be Jeff Atkin and Joanna Katu. Mr. Drake, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer. These are case numbers 217-202-04, 217-0205, and 217-0682. First case, violation, construction of modification of a structure without permits, a violation of Chapter 18, Article 1, Section 18-8A. Unlicensed and inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41, and accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Property owners Ernest C. and Valerie M. Drake. The address is 5345 South Nob Hill Terrace, Homosassa, Florida. I would like to authenticate the following documents and request to be admitted into evidence. Photos taken during the initial inspection on August 4th, 2022. Corrective action inspection on October 11th. Follow-up inspection on December 13th, and my final inspection on December 20th, 2022. Exhibit B, the notice of violation, notice of hearing, and a copy of the continuance letters sent to the property owners.
Okay, so are these the same exhibits for all three cases?
Yes.
Okay, so there's
Well,
no
it's-
difference between the exhibit A in one case or the other case. They're all the
It'll
same.
just the different cases, that's it.
Okay, and you mentioned a continuance. Was this originally set for another hearing?
It was set for the November 16th hearing, and Mr. Drake appeared at that hearing and was told that it would be continued to today's hearing.
Okay, Mr. Drake, what I'd like to ask you to do is to review these documents and let me know if you have any objection to them being evidence in this hearing. And take your time. Sir, do you have any objection to these documents being used as evidence?
I just don't see the unregistered vehicle because I don't have one.
Okay. And I want you to talk about that. For the purposes of the hearing, normally what I need to know is if you think for some reason these photos aren't authentic or if they're doctored or something like that. Do you,
I just don't. They said it was an unregistered vehicle, and
okay.
this vehicle was a truck that I had the nose off it. But that was my personal truck, and that's been back together since a week after the first time they came.
Okay. Is there anyone from the public who's going to want to be heard on this case? I was just wondering now. Okay, I don't see any. Okay, then without objection, what's been proposed as exhibits A and B will be introduced as evidence in all three cases, but I will note that Mr. Drake has comments that he wants to make about this to indicate it goes towards the evidence. So thanks.
An inspection was conducted on August 4th, 2022, and photos depict the structure without a permit, unlicensed and inoperable vehicles, discarded auto parts, and miscellaneous debris on the property. I have had contact with the property owner, Mr. Drake, and explained the violations. As of my final inspection on December 20th of 2022, the property remains in violation of all three violations, and no permit has been issued for the structure on the property, the metal frame structure, pole barn type structure.
Okay, so let's just walk through this very quickly. I've got 5 photos in Exhibit A, and the first one is dated August 4th, 2022. Is it the county's contention that there was a junk case at that time?
Yes.
Okay. And then the next photo I have is from October 11th. There's another, and then I think the final 3 are from December 13th. So I'll need to rely on your testimony, I think, because I don't really see it on August 4th or on October 11th. Yeah, I mean, let me know. Oh, is it over there?
This is the case for there's 3 cases. This is the case for the after the fact.
Okay.
So then they'll be separate for the junk case. We'll have the photos for the junk. It's the same dates for each.
Okay, well that's why I asked earlier if they were the same. So they're not the same exhibits.
No, different dates. Different dates that make the same.
They're not the same photos. That's what I
No.
mean. Okay, so I have different sets of information to prove each case.
Yes, sir.
Okay. Then in that case, let me move the. Let me take a moment just to look through this then, and now that I understand. Okay. And do you understand what Mr. Drake is saying about the unlicensed vehicle?
Yes.
Why is he wrong?
I can't verify that any of them are unlicensed, but there is an inoperable one that's in the photo to the left of the property. It has a flat tire. I believe it's a black truck
Okay.
with flat tires, so it's inoperable.
Okay. I see what you're talking about. And then I'm now looking at the junkyard conditions photos. Okay. Okay. Is there anyone else from the county who wishes to testify before I hear from Mr. Drake?
Land Development Director Joanna Coutu.
Introduction and everything. Most of this is medium density residential. They have a small corner. It's mostly in the setback area on the left-hand corner. That's PSO. Appears to be auto repair, but couldn't find any permits for the structures. The last permit I could find was 2007, an electrical upgrade.
Do you know if anyone, if Mr. Drake's had any contact with y'all about getting a permit yet, or?
Not with our office, and I don't think with building. I couldn't find any notations. I'll let building answer that.
Okay.
Jeffrey Atkins, Assistant Building Official. Yes, there was a permit applied for a metal building, but in looking at the pictures, all the structures would be required to be permitted. The only exception would be a portable canvas, temporary type structure. That wouldn't require a permit.
Okay, so hold on. What do you mean by all the structures will require a permit?
Any structure that was so erected without the benefit of a permit would require a permit. So from looking at the photos, it appears that several of those buildings or combinations of buildings on the right-hand side would have been required to be permitted.
I didn't notice a combination. I had just noticed one. So I'm.
It appears that it looks like it was a temporary canvas type structure, and then there was a separate white building in the back, and now there looks like it's a metal building and something off to the side on the new picture.
I mean, I'll tell you that what I
The one
have.
he's talking about is a shed that's been there since I bought
Okay.
the property in 2000.
Okay, there's a shed.
Yeah, it's been there since I bought the
Okay.
property.
Right.
The only difference, I took down a fence, I used to cover it all,
Uh
and
huh.
I should have left it there.
Is it a portable shed?
No, it's a permanent shed. It's
Okay.
been there since I bought the house in 2015, and the shed was there. But they told me I had to have a permit for the building that I have, the metal building. But if you go back in the things, you'll see where my neighbor's been complaining since I put the portable, it's portable. I went, they told me, I came down, got a permit, my file for the permit, they told me I needed an engineer to come look at it. So I went and got the engineer that you guys pay that's working on the county roads. Got him yesterday, came over, had him look at it. Said, you see anything where I have to have an engineer? He said, man, it's portable. It's all bolted together. The neighbors were complaining about tarps. Every time I turn around, my neighbor turning me in for tarps, cars, this, that. They turned me in once. I had to go and register 7 of my cars because they're unregistered. So that's how I know everything in my yard is registered. The Bronco's got a flat tire. I didn't know a flat tire was inoperable. I mean, I put air in a tire. It does run and drive.
That is what it
Well,
means.
when they said unregistered, there's nothing unregistered. Every vehicle in my yard is registered. But as far as the structure goes, I mean, they got one person telling me that it's considered a permanent structure. They need a permit for
Well,
it.
let's talk about the structure first, because
And everybody else is telling me that I don't need a permit. I have contractors come out and
If you don't mind, hold on. I just want to figure out from the county's perspective what's going on, and then I'll get to you. So, how many structures on there? Do you know? Is there a number that you think require permits?
From what I can see from this photo, I have not personally been to the site. It looks like one large metal building and one small storage building in the
I can
back.
see the first one. I can't see the second one. I'm not. He's already testified that there's a shed.
Yeah, I
there.
mean, if you pull up the aerial,
Yeah.
the aerial goes back to 2010.
Well, they didn't give me
and
that
it
as
shows-
evidence.
And it shows the shed. What he's talking about is a shed that's right over here. That's not my product. That's behind me. This is all one piece.
I don't have that evidence in front of me, so what I need to understand is what the case is for on the permit.
Yeah, that building's gone. That was a portable garage. That's gone. That was a van that I had there. And that's my shed that's been there forever. That's what you're seeing in the other picture. That's still there. That's still the shed way over here in the corner. Like I said, if you look at the building, it's actually 66 feet long. There's a 40-foot, 20 by 40 behind it, and a 20 by 20 in front of it. They're hooked together. The neighbors were complaining about tarps. I mean, I had the county there calling me constantly. Neighbors are complaining that tarps look ugly. This is ugly. That's ugly. So I put metal on it. So there, I'll shut the neighbors up. I shut them up for a couple months.
Mr. Drake, if you don't mind, hold on. It's just I need the county attorney to be able to hear this.
And the building that he cited for is the metal building, not the shed.
Okay, so we're here on one after the fact permit and one structure.
Yes,
Okay,
sir.
all right.
Great.
So that makes sense, and
Right.
I appreciate you giving me the additional information. I just didn't understand. Okay, so we're here on the large one that I think is 60-something feet, and you've
But only 20
Have you
feet-
talked to the county about
only
getting
20,
a-
Only 20 feet of it has metal on it.
have you talked to the county about getting a permit for this
Yes,
structure?
I went to get a permit.
Okay.
And when I went and filed for the permit, they gave me the paperwork, told me everything I needed. They
Okay.
said, they mentioned engineer, so
Get
I
the
went.
engineer.
So I went and I stopped the engineers working on the county roads
Uh-huh.
yesterday. Went and got him, hey man, I gotta go to court tomorrow. Come over, take a look at
What's
this.
that engineer's name?
I don't know what his name is. He works for the county. He's doing the road work with Watson Civil. I
Okay.
went over and got him. He came over and looked at it. Real nice guy. Looked at it. He said, man, he said, I don't see where there's a problem.
He may not be
He's like-
aware.
He's
you know,
like, you got a metal, it's all metal poles. The metal poles go all the way to the concrete. There's one post that they said didn't reach the concrete, said I braced it with, I didn't. I cut one post off because it was actually concrete in the ground when I moved it and I had to cut it off.
Why is a permit necessary on this structure?
A permit's required by the Florida Building Code for any structure, especially with a foundation and overhead roof system. From, again, what I see here, this building was constructed without benefit of permit or inspection.
And that's as distinguished from like a tent, where there is no foundation
That's
on a
right.
tent.
It's a permanent structure.
It is a tent. It's metal pipes with
Well-
metal screw, with the fern strips screwed on with screws and metal screwed to the fern strips.
Has Mr. Drake seen these photos? Okay, do you have any objection to them being evidence in your
No.
case? All right, this is gonna be Exhibit C and case number 2170204. And I'm gonna go back to the first set of photos to look at this structure. It doesn't look like a tent to me. It looks like you put a metal
See
roof
that-
on it.
The biggest thing is I called the code enforcement officer, wanted him to come there, show me what I was in violation of, so I could show him the inside of the building, show him how it's metal poles. Not once would he ever come and talk to me. He would drive by Like, yeah, the other day, drove by, jumped out of a truck, and I was sitting on a porch and watched her walking down the road, taking pictures, jump in a truck and take off.
Well, let me
Somebody else
read
is
the
driving
code
the truck.
section that's at issue here. It says, "No person shall erect, construct, enlarge, alter, repair, move, improve, convert, or demolish any building or structure subject to this code." And what the county's saying is this is a structure subject to the code because it's not as portable as a tent. It has what appears to be a roof that's pretty. I mean, it's not insubstantial, you know.
There's 13 screws, and that roof will come off in 2 sections. Both sides slide off.
And there's no and the Florida Building Code doesn't care how many screws are in it. I mean, there's no difference between 13 and 26 and 64 in the Florida Building Code. So I understand what the county's saying, and you've already done the work. You've done some work towards getting a permit.
But when I first put this together,
Yeah.
the last code enforcement officer was a heavyset guy. He came because the neighbors were complaining about the tarps. He came and was in that building, and I showed him what I did. He's like, "Oh yeah, man, you're fine." Why didn't he tell me
Well, that's
3 years
interesting.
ago?
What code enforcement
3 years
officer?
ago that I needed a permit.
Now, here's the thing about how that works. So, in Florida law, if someone on behalf of the government makes a mistake, someone later on can still come back and correct it as long as they are right under the law. In other words, unless you spent $1 million or something like that, relying on that first person's opinion, but it doesn't sound like that. It sounds like someone came out and told you you're fine, but now the county's reconsidered their opinion, and I have to decide whether they're right or wrong.
Yeah, I'm just saying. I
Yeah.
mean, he was standing in the building. I did. It's
No, I
actually,
get it.
It's been like it is for 3 years.
I believe you.
And
Yeah.
I mean, when they started complaining about the tarps, he came and comes out and he's like, "Look, man, just do something to make it." So I said, "All right, man." I put the metal on.
How long will it take? I mean, what's the process for getting an after the fact permit on something like this?
Um,
Because he mentioned the engineering.
Right.
Doesn't look like there's much engineering on this, but
After the fact permit, you need to apply for the after the fact permit, provide a floor plan, engineered as-built drawings, or an engineer's letter certifying its construction, because we don't have the benefit of inspecting the foundation, the pole embedments. A lot of the rest of it is visual, and we can visually inspect it. But there is a portion that will require engineering, and that can be in the form of an engineer's letter certifying its construction, but I still have to have some type of document documenting the floor plan and layout of the building.
So the
It's a
best
utility
thing,
structure, it's very simple.
the best
I
thing
was
for
just
me to
gonna
do
say-
is take the metal off it, put the tarps back on, and let the neighbors complain about the tarps.
I'm not sure that's sufficient because what it sounds like is there's some kind of foundational aspect. Okay.
That is correct.
The foundation was there when I bought the house. I mean,
So
it
here's
was always there.
Well, Mr. Drake, you've conceded that there's a foundation now. So, I mean, that makes it easy for me. But here's what's important to know about property ownership. If something's there before the fact and it violates the county code, you as an owner are still responsible. Now, if the seller told you that there was nothing there that was illegal, that everything was totally fine, you may have a cause of action against them.
Yeah, I said there was a
But the
fence.
county still
I
enforces
took
its law.
If I would have left the fence right across the front of the garage the way it was, I wouldn't have any of this problem.
I don't know the details on that, but I think that on this one, the county's right. And on in which case, Mr. Drake, what I would need to know is how much time you just need to do what the county said you would need to do, which is
I'm going to put it back to the metal pipes and the tarps because they didn't bother me with that.
well, whatever. I would just make sure that that would satisfy what the county wants, because as far as I'm concerned,
I mean, to
you
get a
just
per-
have to abate the violation.
to
I
get a
don't-
permit
I don't
in
care.
this county, to get a permit in this county, it's
Mr. Drake, if
crazy.
you don't mind, what I'm basically saying is I don't care how you fix the violation. You could tear the thing down, you could get a permit, you could do modifications to it that satisfy the county. I don't care. What I need to know is how much time you need to do with any one of those things. Is it a month? Is it 2 months?
The base thing is to get a permit is they want you to jump through hoops to do all this crazy stuff. I mean,
That's-
I gotta go pay
that's-
somebody to come out and do drop site plans. Then I gotta have somebody come survey the property because I don't know where property lines are, and the guy bought the property next door, he's trying to tell me he owns more than what he does, and I'm really, like I told another guy who wanted to buy property in Citrus County, I said, don't do it, man, go elsewhere, don't do Citrus County. It's like, you'll have number of problems, don't do Citrus County. But I'll put it back to the metal pipes and put it back to the way it was. It's just all I gotta do is pull the metal out and put a tarp on it.
How much time would you need to do any one of those things?
Put a tarp on it?
1
30
month, 2
30
months?
2 months. and I
I'm not
have it-
saying a tarp is sufficient. What
2
I'm
months, I
saying
can have it
is
back to the way it
whatever
was
it takes
when they
to
didn't-
abate
when
the
the neighbors
violation.
complained.
Would it be 1 month, 2 months?
Probably 2 months.
Okay. Let's talk about the next case, which is the unlicensed inoperable vehicle. Now, what is surprising to a lot of people is exactly what you just said earlier, which is, does a flat tire really constitute an inoperable vehicle? It turns out that it does. So let me read the definition of an unserviceable vehicle. It says, shall mean vehicles which have any of the wheels or tires dismantled or uninflated. I don't even need the rest. It's a whole paragraph of a definition. Basically, everything under the sun is thrown into it.
Yeah.
And it was surprising to me when I read it. I'm not surprised that it's surprising to you. Nonetheless, if you've gone out and done the work of getting everything registered, you're halfway there, but that tire's got to be inflated if that's the only part of the violation.
Yeah, I mean, I got 7 vehicles on the road. I don't need to drive. I can't drive. There's only 4 of us. I can't drive all 7. And that's the problem I have. But I have to have all 7 registered and insured and movable. Otherwise, it's a violation.
Correct. Or you could sell them. But either way, or move one. But either way, under this code section, you've got to fix it.
I actually did move that one because there was a blue truck parked there. The blue truck they were complaining about because it wasn't registered and insured. So I took the black one from out back that was registered and insured, put it where the blue one was, put the blue one out back so they couldn't see it.
So, Mr. Charles, I just want to make
I mean,
sure
it's just
that
crazy.
basically the county's case is it's the black vehicle.
It's
There
the
was
blue-
the original case was a blue vehicle, a blue Chevy pickup. That was the original case. When I called, that's what they told me. It was a blue one.
Well, I see the blue one. Mr. Charles, is the blue one still there?
I can't verify.
The blue one's
Right.
gone. The blue one's covered. You can't see it. They told me it had to be covered or removed.
Okay.
So it's still on the property.
Is the blue truck still on the
Yep, it's
property?
got a plate on it too. It's got a transporter plate.
The blue truck.
Yeah, I got
This one from
everything
page-
I have has a plate on it.
Okay, so on page 1 of Exhibit A, is it this blue truck
Yeah,
that
it's
has the
still parked.
decal?
It's still parked in the same spot with a plate on it.
Okay.
If you go behind it, it's got a plate on it.
And Mr. Tron, you can't verify that because you haven't seen it.
Yes, right.
Okay.
I can't see it now.
He's whoever I talked to when I called, everyone told me to put a fence up so the neighbors couldn't see it because the neighbors were complaining about it.
Have you not been given permission to inspect, or?
Yes, I've been out there and inspected
Okay.
it. Yes, on the 13th and the 20th.
Nobody's ever been on my property, physically on the property,
All right.
with any permission.
What
I
about
haven't
the
seen
red
on my
Dodge
camera.
pickup? You know what I'm talking about?
That was in the garage. That's gone.
It's gone?
Yep.
Okay. I mean, based on the evidence, what I see as still existing today is the black truck.
Yep.
I do find that there's a violation on it. How
Yeah,
much time would you need to fix it?
5 minutes, blow up a tire.
Okay. And then the last case is the junkyard conditions case, which, I see it in the August photos. It appears that there's a bunch of debris. I mean, it's organized in where the debris is, except in the very back where there's a bunch of tires. And then that seems to
Those are
improve.
all- those are all gone.
That seems to improve by October. Are the tires still there?
Not that I could
No,
see.
they're gone.
What still constitutes the junkyard violation at this
The
point?
discarded auto parts that's there. There's a white truck bed without tires. It's just the bed of the truck. Just it's propped up with rims, and then you have the car doors in the back of the photo next to the black truck in the back, and some discarded items up front. I believe it was a trash bag or something like that near the shed.
I see a one Drake's license plate. You're not going to let that one go out of date. I mean, you've heard the county's case. It does constitute junk and debris under the county code. For example,
But the thing is when they first came out to my house, I asked them what I had to move. I called them. oh, you need to put a fence up, cover the blue truck. I did. Never once did they say anything about anything else. Now all of a sudden they're coming to take more pictures and telling me that it's this and this and this. Well, how come originally when I called the man, he couldn't come out and see me and tell me what to do? My neighbor, Jeff Queen, I wish he would have came with me because same exact problem. Wanted his camper moved. Told me he had junk and debris and this and that had to be moved. I went and moved his camper.
The one
He
thing
called. We stood right in his yard and called together.
the one thing I can tell you is, from my perspective, is it doesn't really matter whether someone said something in the first place. What matters is there currently a violation? So, whatever happened in the
But
past,
my
I don't
thing
know.
is if they originally came and told me what was in violation,
Right.
then I knew what to fix because I would have put the fence all the way up to the front.
Yeah,
where
but
it
I'm not
should be,
issuing you
know?
a fine today. I'm
No,
not
I'm
fining
just saying
you.
it'd have been better if I'd have known from the start what was in violation
Okay.
instead of waiting until we come here. I mean, they said they put sticks in my yard with notes on them, which I call a lawyer. He said that's illegal.
Well, this is the
That's
trial.
irrelevant.
This is
And
it's not illegal, but this is the trial here. And the thing about it, the reason why you're not necessarily prejudiced by that is that I'm not fining you today. What happens is I have to give you
Yeah, I understand that.
time
It's
to
just
fix
that
whatever.
it'd be nicer because I could have
I
had
hear
it fixed
you.
way before this even came about. If somebody would talk to you in the beginning, when you call, leave voicemails, nobody calls you back. Then, like he says, he talked to me once. And that was about a blue truck.
Mr. Charlton, you did want to be heard. I want to give you an opportunity.
I've spoke to him because he was calling about the previous code officer there, and I spoke to him, and I personally.
Who was the previous code officer?
Officer Matt Hampton.
Okay.
And I explained to him myself on the phone on what needed to be done, and we never talked about hiding violations. I can assure you that.
Yeah. That's
It was a
not
blue
county
truck.
style.
This was the only thing I was told about, blue truck. Like I said, the other guy's the one that stood in my garage and told me, well, listen, your neighbors are complaining about the tarps, make it look better. I put the metal on it, he came back. I wish he'd have told me then that it wasn't legal, so I would have left it as the pipes with the same as it was with the tarps.
So the same question on this case as I have on the other two cases, which is how much time would you need to fix the junkyard conditions?
30 days, and I can fix it.
Do you understand what needs to be done?
Yes, yeah, I do.
All right. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has been abated in order to allow for reinspection.
What I'm going to do is I'm going to adopt the county's proposed facts in the three cases. I'll find that, Mr. Drake's in violation, but for each case, I'll grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. That's for each case. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Drake. County Attorney's Office may seek foreclosure or a judgment if the lien is recorded for 3 months. And if it gets to that point, you'll be required to pay any costs required by the law, but you've got 2 months to fix it all. Okay.
Now, take the metal off, put it back to tarps, I'm good.
I don't know if that's enough. What
I
I do,
mean, it's a metal pipe building that's still
you need
there
to
with the
talk
metal
to
screwed
you.
to it.
You need to talk to the county. I do know that either you can get a permit for it or you can take the whole thing down. I don't know what modifications will satisfy the county until you speak with the county.
mean,
And
if
I
you-
wouldn't rely on random engineers that you find on the street either.
Oh, no, he works for the county. He's a county.
Well,
he works for the county. That's
But
why I went and got him.
I hope you understand what
Yeah.
I'm saying.
Yeah, I
I mean,
understand.
yeah. All right, and that's it. Thank you.
Next case on today's agenda, Carol A. Howard, Revocable Living Trust, July 3rd, 2015, case number 217-4495, Code Officer Brandon Norman. Experts on the case, Joanna Coutu and Jeffrey Atkin.
What page of the agenda?
Excuse me, it's page 8 of the
Okay,
agenda.
thanks.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning.
Morning. Okay, good morning. Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-4495. Chapter 18, Article 1, Section 18-8, Subsection A, obtain after-the-fact permits for all construction or modifications of the Citrus County Code of Ordinances. The address is for 8605 East Lake Breeze Lane, Inverness, Florida 34450. Property owner listed as Carol A. Howard Revocable Living Trust. I have good service signed via certified mail return receipt. I would like to authenticate the following documents. Request they be admitted into evidence. Exhibit A is photos taken during initial inspection on October 12th, 2022. Photos taken at my compliance inspection on November 18th, 2022. And photos taken at my final inspection on December 20th, 2022. Exhibit B is going to be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Right, sir and ma'am, I'd like to ask you to look at these documents and let me know if you have any objection to them being evidence in this hearing. I don't want to rush you. Take your time looking through these.
No objection.
No objection, okay. And what are y'all's names for the record?
My name's Ray, and this is my mom, Carol.
Carol, okay. And are you both trustees of the trust or just?
I am.
You are, okay, thank you. A lot of people don't realize that trusts don't actually own things, but trustees do. So I don't really care what the trust is. I need to know who the trustee is. Just an academic legal point, yeah.
Yeah.
All right, thank you. Without objection, what's been proposed as exhibits A and B are evidence. And also, I just want to ask early on, is there anyone from the public who is going to want to be heard on this case? I don't see anybody. All right, thank you.
On October 12th, 2022, an initial inspection was conducted of the property for a storage shed at 8605 East Lake Breeze Lane in Inverness. Research was conducted in Hanson and was determined that no permit was applied for. On November 18th, 2022, I conducted a compliance inspection and found the storage shed to still be on the property without a permit. On December 20th, 2022, the shed still remains. As of today, no permits have been issued for the shed. I have been in contact with them. I believe I spoke to them on the November 18th compliance inspection and informed them what I was there for and what the process was for them to obtain the after-the-fact permit. So,
And what was their response when you went and talked to them?
they were super polite, very compliant. They understood. They informed me that they would begin the process to apply for the permit.
When did those conversations take place? It looks like you issued a notice of violation on October 10th.
I did. I apologize, it was a typo for me. So it was October 10th. So, but the conversation that we took place about the after-the-fact permit was at my November 18th compliance inspection.
Okay.
So.
All right, so it's been about a month, and where are you guys at in the process? Do you agree that there's a violation or not?
I built a shed without a permit.
You built. I don't need to hear any more testimony from the county. That makes it easy. I appreciate your candor. So, what are you trying to get a permit at this point? Okay.
When the notice first came out, she was in Africa. It went to her house.
Okay.
When I first learned of it was when I met Brandon.
Okay.
And I met Brandon, I think it was the 18th of November. I came up with the following Monday. I came here, spoke with Brandon. He walked me up there to where I get the permit. They were explaining everything to me, and they said, "What's the name?" And I said, "Trust." And they said, "You can't do a thing." So I've got a builder in line. I've got somebody to move it if it needs moved. Then they told me that...
Oh, because you couldn't do it yourself. You would need the trustee to actually go ahead and...
Well, they said since, excuse me, since it was in a trust,
Yeah.
that we couldn't touch it. We had to have a contractor.
Okay, I don't know what that means.
I think it means he's saying they could not apply for an owner-builder permit.
Correct. Yes.
But the trustee is the owner.
I am.
Yeah, you're the owner.
Yeah, they told me that.
So that doesn't make any sense. All right. Well, I mean, it may be that, you know, the trust... I could understand the trustee having to designate somebody, you know. Well, so you're in a situation where you're at a standstill because you don't know how to apply for the permit?
We don't know what to do.
Okay, well, I can
That's
tell
all
you
we
for
wanna-
sure, I can tell you for sure that the trustee is the owner of the property. So if it lists the,
I was in Africa though when all those notices came out.
oh no, I hear you. Actually, here's what I'm gonna do. Is there anyone at the county who's had any conversations about this or is aware of the permit process that, is it Ray Howard?
Yes.
Or Ray Howard has gone through? Is there anyone from the county who's able to testify?
Jeffrey Atkins, Assistant Building Official. You are absolutely correct. The trustee is the person who can apply for the owner-builder
Yes.
permit. I believe, ma'am, you are the trustee?
Yes.
Okay, so you would have to be the one to apply for the permit for the owner-builder for the shed.
So we don't need to bring contractor into this now.
As the owner-builder, you can apply for your own permit. At this, what I would need is a floor plan of the shed, shows the outline, and an engineer's letter certifying its construction.
Okay.
Because the anchoring we can inspect, we can visually see it.
The other thing they told me on the engineering, with the contractor that I've gotten in touch with, he said for engineering, what I'd need would be the actual original book and to be able to prove that it was a Florida-approved shed.
Okay, let me ask you, you stated that you built the shed?
I did.
Did you buy it from a kit or did you?
It's a kit.
Okay.
I'm gonna
Yes,
stop you. Yep. This is a conversation for outside the hearing.
correct.
How much time do you need to, do you think, go through this process?
Now, the other question is they're telling me that I need a survey that is within the last 5 years.
I understand. I mean, as a city attorney, I'm familiar with some of these rules. I don't know what the case is here if you need a survey or not. It's pretty common. But it's kind of irrelevant from my perspective. I understand it's relevant for yours because it's like, how much time do I need? I need to get a survey. I need to get this and that.
Exactly.
What's the county's perspective on how long this process normally takes? And is a survey necessary?
At this point, I would tell you on owner-builder permits, the requirement is a site plan that actually shows the lot lines, the setbacks to ensure that the shed is complying with that.
So you're
requirement.
not saying that a survey is necessary, but a site plan is necessary? Maybe a certification that they own it in the site plan or something?
Yes. 90 days to get the process going and get them under review and an issuance is very reasonable.
Okay, did you hear that?
90 days?
Yeah, so I mean, what I would probably do is give 120 for a little leeway, not knowing if there's delays and finding someone to help you. Or
Yeah,
not.
he's got the paperwork that I got up here for the site plan and
Okay.
everything. That's
Okay.
all we're trying to do is figure out what we have to do.
All right. Then I'm going to find that the property is in violation. I'll adopt the county's proposed findings of fact, and I'll grant you 120 days from today to abate the violation. Okay? What is the county's recommendation on the fine if they don't comply within 120 days?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 per day along with the administrative cost to begin after the day that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So $50 a day is pretty much the lowest that's ever been recommended to me. It's the lowest the county goes. I think they understand, the issues. So if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. That would be recorded and constitute a lien on the real or personal property of the trustee here. But the county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And if it gets to that point, the property owner would be responsible to pay all costs required by county law. And that's it. Okay? Good luck.
Thank you.
Thank you.
Thank you.
Next case on the day's agenda, Jeanette D. Cone and Anne Marie Sardini, excuse me, and Cheryl Lynn Lewis. Code Officer Brandon Norman, case number 217-2581. Expert on the case, Joanna Coutu, page 23 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you please state your name for the record?
Sherry Lewis.
Larry Lewis.
Thank you.
Thank you.
Good morning again. Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-2581. Special requirements for all accessory structures, a violation of Citrus County Land Development Code Section 3102A. The address in question is 855 East Gobbler Drive, Floral City, Florida, 36636. Property owners are Cone Janet D., Sardona, Anne Marie, Lewis, Sherry Lynn. I have good service via certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is going to be photos taken during the initial inspection on September 8th, 2022, and corrective action inspection on October 10th, 2022, and photos of my final inspection on December 20th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the certified mail return receipt.
Ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing. Okay, so you don't have any objections?
No,
All right.
we don't have any objections to all of it.
Okay,
We did what he said we did.
I gotcha.
We just didn't know it.
You're making it easy for me.
Yeah, I mean, I could explain it real quick.
Oh, and that's fine. First I'll have them present, because maybe I don't agree. Who knows?
Okay.
But without objection, what's been proposed as exhibits A and B are evidence. And is there anyone from the public who wants to be heard on this case? All right, I don't see anybody. Thank you.
On September 8th, 2022, an initial inspection was conducted at the property for an RV on a vacant lot. The property was found to be in violation of the above ordinance. The property remained in violation of my notice of violation correction action inspection on October 10th, 2022, as well as my pre-hearing inspection conducted on December 20th, 2022. I was able to make contact with the property owners and advise them that in order to abate the violation, the RV had to be moved from the vacant lot onto the lot that had a primary residence.
Okay, and what was their response?
We had a couple conversations about different actions that they could do. They said they were going to contact the permitting office and see about doing a unity of title. From my understanding, though, that's not going to abate the violation because there's still no primary structure on that vacant lot. So
On the other lot, there's no primary structure.
on the lot, that's because the lots are adjacent to each other.
Yeah, but there's no resident. There's no
There's no
residence
primary
on,
structure on the property in question, which is the 855
but there is one on the other.
adjacent. That's yeah.
Why wouldn't a unity of title fix that?
Oh, not the case. Sorry.
No, you're fine. Unity of title will not fix that. Unity of title is for structures and not for uses. In this particular, it will not allow storage. You can use it for a shed, but unity of title won't work for an RV for storage. They can either combine the lots. Some
Is that
people are
because
doing
of
that.
zoning
That's
or?
what the unity of title is doing, is combining the lots.
No, the unity of title is for structures to allow you to get a building permit on a vacant lot where you own a house next door. This is not a structure. This is an RV. It's for a use. So the unity of title was not designed that way. It was not. It's only for structures.
I just want to make sure I understand so that I can, figure it all out. But so if this was all one lot to begin with, and
Then we wouldn't be here.
okay, but the unity of title doesn't create one lot?
It does not. It's still two lots of record, but the unity of title lets you put an accessory structure on the vacant lot because you have a house next door and you would like it to be treated as one site.
Well, what does the unity of title do then? I mean, what does that mean? Is it just a form?
It's a form that they fill out and record, and they said that it's permanent, so you will never treat that other lot as a separate building lot to be developed as a primary structure. We're saying we own
So
two.
you're saying they'd have to replat in order
They would have to replat if
get
they want
rid
to
of
keep
lot.
the RV on this vacant lot,
Okay,
yes, or
so-
build, yeah.
So unity of title process, I understand. So the unity of title process is something short of getting rid of the actual lots as platted.
Right, there's still
which is
two
what
lots.
you're saying would be required.
Right.
So that's the only way to get one lot is replat it.
Correct.
Okay. Does that make sense?
It does.
Now, what we've done,
Yeah.
you want-
To us, it was our front yard.
yeah, we didn't think
Oh, I
anything about
understand.
it. So
Yeah.
what we.
No, I
what
get
we-
it, yeah.
What we've done is on the 18th of November, Coastal started the survey on the property for the unity of the title. Then we have the engineers are gonna come in right behind them and do the stormwater management, because we're gonna put a building on there, a permanent structure, which is gonna eliminate, we're gonna do the unity of title,
put a permanent structure on it, which will eliminate
You,
all.
you're going to put a principal use on the vacant one.
Right,
Correct.
we're gonna put a garage.
Okay.
And I
On the
came
other
in,
side of the driveway.
when I came in to pull the permit for the garage, that's when I found out that the regulations had changed and we had to have the survey and the engineer and stormwater and all that other stuff. So they came out.
Yeah, the quickest we could get the surveyors was 18th of November, just happened to be lucky and get that.
No, that's
We
fine.
haven't heard anything from them yet. Haven't seen
What
anything.
are you putting on this lot?
Just
a
a
garage.
24 by 25 garage.
Is that enough? I mean, is it residential?
It's going to be on a concrete slab.
The garage, pulling the building permit for the garage, yes, the unity of title would work. It won't cover the RV, okay? It's
Right.
it's still a separate lot, but it would allow them to do a garage. I'm assuming your waterfront in that, you have
Correct.
waterfront. So that's the stormwater thing. Nothing's changed. That was a requirement for many years, but
But we're
told
only
us
here
to
on the
change.
RV.
We're only here on the
So,
RV, right.
Do you understand that what you're talking to me about will not fix the problem?
No.
Not until now.
I'm telling you.
Because
So
we were told downstairs
if
it would.
you
but
want
okay.
if you want to abate the violation, you're going to have to do, as far as I know, one of two things. Either you're going to have to build something that constitutes a residential structure on
Yeah,
the
it's
property, like a
it's not-
house.
Yeah, it's not wide enough. There's not enough setback. We can't do that.
Are you planning on putting the RV in the garage after you build it?
No, we had actually planned on putting the RV on the side.
Okay, so that would not resolve it, but if it was in the garage, that would resolve it.
Would it?
Would it?
Garage door shuts.
Yeah, I wouldn't have
See, this is the
suggested that,
problem
but
That's an
with this whole
interesting
thing.
idea.
you're on the right track though.
Somebody-
They need to either move the RV to
Yeah,
where the
it's
house
gotta
is, move the RV where
Yeah.
the house is, or just take it away. Future garage is whatever it is, but
Okay. Those are the options. So what I need to know is how much time do you need to do it? Actually, there is one other option, but it's not one that no one can guarantee that it'll ever work, and that's that you could seek a replat of some kind. I
What's
don't
a
think that's
replat?
going to. I don't even want to get into it. You'd have to consult with a lawyer, which is bad news as it is.
Okay, so I just want to make sure I'm understanding. We're doing the unity of title. We used to, my wife and her family used to own 2 lots. Now it's going to be 1 lot, but we still
It will
can't-
not be one lot. So this is what you need. This is why I was confused. I didn't see the point of why you would do a unity of title unless it did become one lot. But what they're offering you is a way to do certain things you can't do by just having 2 lots. But they're not going to recognize it as one lot. They're going to say, okay, you've got 2 lots that are adjacent with each other, so you can do certain things. One of those things is not going to be that you can keep an RV there without a house. So you've either got to move.
Even though the lot's not big enough to put a house on.
That's right.
Okay.
Well, so maybe you could seek a variance. I don't know. I really don't know. But what I do know is your solution as it stands is not going to be enough. Okay? So what I would need to know is, and I really encourage you to, I hate to say it, talk to a lawyer about your options, whether it's seeking a variance or a replat or whatever, but I can't do that for you. I'm not your
Right.
lawyer. I don't know.
Right.
What I need to know is how much time you would need to figure out where to put it,
Figure out something.
to get it off there, or to put it on your main lot.
Well, we can put it on the main lot, but the only reason we were doing the unity of title is we were with the understanding if we put a permanent fixture on it, that it would.
No.
Let's see, that's a lot of problem we've had with all these different things. But okay, can we get about 90 days? That'll give us enough time to figure out what we're going to do.
What's the
and-
county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day, along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they are advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
What I'm going to do is I'm just going to briefly read the code section, and just give me one moment. What's the, what is this zone for? CLR.
And we put it there because we didn't want it to stick it in the front yard for everybody driving down the road to see. We thought it could be an eyesore. Turns out it was.
Well, we figured if we put it in front of the house, somebody'd call because it was sitting in front of the house.
You're gonna see CLR, like all the residential says accessory structures, but of course there's the other.
What I'm interested in, and I guess just what I want to look at, and I can never find that code section for CLR. There's a whole table, right?
Right, there is a table, and it includes accessory uses, but it doesn't overlook 3102, which is the one they were cited for with the accessory use.
Where is the table, or where is the
Chapter 2?
2? Oh, okay. Here's one I'm wondering from the county is, it says in the 3102A that you can't have a residential, actually let me find the exact words instead of making it up. I'm looking at sub B. Accessory structures shall not be occupied as a residence with the exception of guest cottages / garage apartments. So what I'm wondering is if they built a garage that had a garage apartment.
Yeah. I mean, there's all options like that. I didn't want to go there because I think this isn't the really issue. Yes, they have that option always to build a garage apartment. They can build, as the county attorney's office suggested, a garage to hold the RV. There's some options there. The simple one is to move this off the lot right now, and then they can do that later.
Okay, but that changes things because I thought, when we were talking about it, it sounded as though the garage would be insufficient to store it.
No, I mean, we're not going to, with a unity of title form,
Okay.
they can do any kind of accessory structure they want to over there, including a huge carport, perhaps. The house is whatever they want to put in there.
I know that wasn't their plan.
Right.
They weren't going to put the RV
And I don't want to
in.
commit that to them. I've had people before you promise permits and never see them again, and they call us and they
I'm
want
not
to do
hey,
it.
I've
No,
never
I know,
promised a permit.
I know,
Yeah.
but people have told you that, and then they don't. And I'm not saying
for
they
sure.
will. I didn't want that to be part of this discussion. But
I have to know because it relates to how much time is reasonable for them to comply, to abate the violation.
that's a lot of engineering and plans. And if it's a garage apartment, if it's an apartment, that's impact fees. There's a little bit more to it. And they talked about a concern about setbacks. So, that may be an issue for them too. I don't believe that it's not buildable like they said, but it would be difficult. It's going to be a challenge.
You think it may be? Yeah, I mean, it'd be very odd to have a residential lot that wasn't buildable. And usually in that case, it's either non-conforming or
right.
variance
We
or
find a
something.
way, and we can do averages in the area, et cetera. But
Okay.
The lot's 50 foot wide and 150 foot long. It's,
that's not a not buildable lot. I can build
Yeah,
on
no,
that.
that's yeah.
So,
we're told it's not buildable.
so let me ask a question if you don't mind.
It's buildable.
If we put a carport, permanent carport to store the RV in, is that acceptable?
If you had the unity of title form and had a permit for the carport, yes. But you'll need
Put the RV in a carport?
It's not all you have to do. It's a big deal to get those engineering for that carport and a permit. Okay, and you will have to have the unity of title
Okay,
form.
so it
but
sounds
yes.
like all
We
right.
got all
So
that going, so.
all right. So I was under a mistaken impression that a unity of title wouldn't help you at all. It sounds like it could. So there are ways that it can help you. I don't know how long this process takes, either the unity of title or the engineering that it takes to do
Well, the
this.
engineers told us that we wouldn't hear from them till after the holidays.
And then whatever it takes downstairs as far as turnaround, because
Okay.
we have all the paperwork, we
All
just
right.
gotta, so that's why I said 90 days, I was kinda hoping that would,
I'm going to find that the property is in violation. I'm going to grant you 150 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and would constitute a lien on your property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. That's it.
thank
Okay.
you.
Thank you.
Thanks, everyone.
Next case on the day's agenda, Gabri Pineda, case number 2174753, Code Officer Alan Jonason. Page 27 of your agenda. Experts on the case, Joanna Coutu and Jeffrey Atkin.
I'm sorry, what page of the agenda?
Page 27.
27.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record?
My name's Gabri Pineda.
Thank
Good
you.
morning.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2174753, Buildings and Building Regulations, Chapter 18, Article 1, Section 18-8 Alpha, or A. Permits, obtain after the fact permits for all construction or modifications of the Citrus County Code of Ordinances. The address is 4662 North Carl G. Rose Highway, Hernando, Florida. Property owner is Pineda Gabri. Did I say that right?
Yes.
Gabri? Okay. And I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 18 October 2022. An overhead screenshot from the property appraiser's website showing the previous structure from 2019. A screenshot from Hanson reflecting no existing permits from 20 December 2022. And a photo from my final inspection conducted on 20 December 2022.
Sir, I'd like to ask you to take a, I'm sorry.
I'm sorry. And Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Okay, sir, you've been here, so you kind of know the procedure, but what I'd like to ask you to look through these documents and let me know if you have any objection to them being evidence in this hearing. Sir, do you have any objection to them being evidence? Okay. Is there anyone from the public who's going to want to be heard on this case? I don't see any response. Without objection, what's been proposed as Exhibits A and B are evidence.
On 18 October 2022, I conducted an initial inspection and observed the property to be in violation. I verified in Hanson that no permits had been issued. On 19 October 2022, a notice of violation was issued for ATF, which is a violation of the ordinance listed above. On 17 November 2022, I conducted a compliance inspection via Hanson and saw that no permits had been applied for or issued. I have had contact with the property owner, but as of 20 December 2022, the property remains in violation. Building Division, Jeff Atkin.
Good morning again, sir.
Morning. Is it just the overhang,
So there was windows and doors that appear to be put into. You can see them in a couple of the pictures. Brand new, a brand new window, and it appears that there's a front door on there as well. When I spoke to the property owner, he indicated that there was storm damage from the hurricane that came through, and they repaired the items that were damaged.
Are they allowed to do that without a permit?
We have what's called an emergency repair order. That's for a general contractor to do repairs, and then they must, by code, within 24 hours, apply for a permit. Water line breaks, electrical disconnects, holes in the roof, that type of repair, if the structure was open to the elements, would qualify as an emergency repair, but we would need the permit applied for.
At some point, anyways.
Within 24
sounds
hours.
like quickly, okay. So what is the county's case, the overhang and a door and windows, or what is?
Any structural modifications that were made.
What are they?
What I can see is the windows and the door and the overhang there. I think it's the front door facing
I'm
Carl G.
trying to see
Rose
the
and
door. I mean, I don't see a difference in the before and after on the door.
It was only the windows. Windows are brand new.
Okay, so you did install windows.
Yeah, because
Okay.
they were broken. from the hurricane.
I mean, the door looks new, but there's no before and after difference with the door.
Right. I didn't have that. I didn't
Okay,
have
okay,
access to that.
all right.
Yes, sir.
So, I also have a more academic question before we get into it. I just looked at section 18-8 sub A, and it says that in addition to the penalties described in this chapter, a violator shall also be subject to a penalty equal to double the permit fee. Is it the county's position that I have to impose that fine if I find someone guilty here?
No, sir.
Okay.
I would say, sir, that after the fact permit by the current owner would generate a double fee for a permit.
Will it? It'll be a double? Okay.
Yeah, that's automatically generated in our fee schedule.
Interesting. Okay. Is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development. They had a pre-up in May for used car sales. Was determined to be a change in occupancy type. Didn't follow through on permits for that. My problem is the overhang. The overhang is not meeting setbacks. They have roads on 3 sides. Very, very tight, constrained area. That overhang is not going to meet setbacks, so we're going to have to look at averages, perhaps a variance to be able to approve that.
So it either would need to be taken down, or they not only have to get the after the fact permit, they have to probably get some kind of variance as well.
I think so for setbacks.
Now, with an after the fact permit, is there a way to get the variance concurrent with it, or is that just a separate process?
They're separate processes entirely.
Oh, okay, that's what I thought. Okay, thank you. So there's some hurdles here. You've heard everything. What's your take on this?
I don't know what to say. Like,
Did you build it without a permit?
yeah, like I
Okay.
replaced the windows because of the hurricane. And
What
then,
about the overhang?
Yeah, it flew off. I got videos, and whenever the
overhang?
hurricane was, yeah. It
There
literally,
was already an overhang there?
yeah, like a really old one. It was when the hurricane happened, it completely flew off to the other side. So I just built a new one. That's it.
So is the wood, like, are the beams, the poles, were they already there, or did you put those
It
in?
was like at first it was like aluminum, so I kind of reused the poles
Okay.
and just bought wood. You know,
So it's pretty much all new.
yeah.
I'm just thinking through if it was already there, if there's any kind of reason why that, it doesn't get you out of the after the fact permit issue. So, you've heard there's an issue with this, which is that even if you do get the permit for it, you may not get the variance that you need for the overhang because it doesn't meet the setbacks on the property. Does that make sense?
It's exactly like the same size as the old one. I didn't do it like any bigger. That's been there for
Well, the thing about that is I don't know if that was ever properly done beforehand or not. It doesn't sound like there's a variance on file or on record that would have permitted that, which means it could end up as a different type of violation, if that makes sense.
Right.
In other words, as you may have heard in one of the previous hearings, just because something was there before doesn't make it right. Am I wrong on this? I mean, is there a basis? Is it a nonconformity if it was there?
Yeah, I looked at the aerials and I did not think that the one that was there before was the same size. If it was, I mean, we'll be glad to look at that, whatever he's got for it. If he's
Okay.
got pictures when it was damaged. You have a 365-day clock to replace existing, recognized, or non-conforming, depending on when it went up. You know, if we can show it's the same one and it's been less than a year, sure, we can replace it with the permit.
Okay.
So we'll look at it, but aerials didn't seem to match up, but I'm not doubting him. He's got something to show me. I'll be glad to look at it.
I thought there was an. Oh, I see the aerial. Okay, hold on.
There's some trees obstructing most of the.
Right, it
It's
is
hard to
hard to
tell.
tell. I went with the property appraiser's size of that awning because we haven't had permits in a long time on this site.
Okay.
And maybe it was larger. We'll look at
Okay.
what he's got.
Well, the only thing that's in front of me is the after the fact permit, and I have to give you an opportunity, a reasonable amount of time to get that permit. How much time would you need to go through that process? Yeah, no, it's. I mean, have you talked to anybody about helping you get this permit yet?
Yeah, I called the the permit, but I just wanted to come here first and see what you guys says, and then I'll reach to them. I'll
Okay.
see what I can do.
Okay, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Reasonable amount of time for window and door change out is not, that's pretty simple, but from what I've heard, that the roof was lifted off and then he had to actually, rebuild it and or resecure it. It's going to require engineering. That is a structural issue. 120 to 180 days because it will require engineering.
Okay, so I'm going to find that the property is in violation. I adopt the county's proposed findings of fact. I grant 180 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and constitute a lien on the property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. The only thing I would also add is you may have heard it was kind of said in offhand, but there's other issues with the property regarding the use. So you may want to try and resolve everything that you can in one swoop.
So where do I need to go? Like to the permitting office? Like they'll tell me what to do?
I hope so. I mean, that's not my department, but I know that they would know, so I would reach out to them.
All right.
These guys. All right. Thank you, sir.
All right. Thank you.
Next case on today's agenda, Paul D. Quarles Jr., case number 216-8529, Code Officer Alan Jonason, page 29 of your agenda. Joanna Coutu, expert on the case.
I keep missing it. I know you're saying it. What page of the agenda?
29.
29. I just haven't had enough coffee, and that's on me.
You're on the coffee.
Yeah.
He's back on the coffee.
Excuse me? Oh, I'm back on. Yeah.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-8529. Special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address of the violation is 11441 North Moonlight Terrace, Inglis, Florida. Property owner is Quarles Paul D. Jr. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 22 August 2022, photos taken during a compliance inspection on 1 November 2022, and photos of my final inspection conducted on 20 December 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
Sir, are you Mr. Quarles?
I'm a member of the public speaking for Mr. Quarles.
You are?
Yes, sir.
You're a member of the public?
Yes, sir.
Okay. And you said you wanted to speak on behalf of Mr.
Yes,
Quarles? Do you have a power of attorney for him, or are you just wanting to?
I do not have any formal
Okay.
paperwork.
Okay.
I'm his best friend and
Okay.
a former employee. We are jointly connected at this property, and he is, unfortunately, it's his silver anniversary. He's on an 18-day cruise.
Wow.
He left me in charge of the situation. There were 190 total items on the property. I have documents. 189 of them are gone. The only one that still remains is singly a shed, and it was scheduled for pickup, and the tow guy was there.
Well, hold on.
The 20th.
Well, no, I am aware of that, and so that's what I was going to bring up. I want to know who you were because you hadn't been sworn in yet.
Right.
I don't know if it'll all be necessary. Here's the issue with these kinds of hearings: is that normally, if you want to stand in the shoes of the person, I either have to have a power of attorney or a good reason, and we'll get to that.
Yes, sir.
Once I let the county present its case, I'll ask if you want to have something to
Absolutely.
share.
Sure.
And then we'll swear you in at that time.
I'll stand quiet till then. Yes, sir.
Okay. Go ahead. Yeah. And I am actually going to ask you to take a look at the, actually, can you swear him in? Yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you
I
God?
do.
And your name, please.
Chad James.
Thank you.
Because it sounds like you have some information on the property, what I am going to ask, I'm sorry, Mr. Johnson, can you actually share these with him? And I am interested to know your perspective. Do you have any objections to these photos? Are they not accurate for any reason?
These photos appear to be accurate at the time of taking.
Right.
Right.
Okay. So Mr. Jonason's not giving me doctored photos.
Not to my knowledge.
Okay. He never has, but I always have. All right. All right. Let me just take a look at these and okay. Please proceed.
Yes, sir. On 22 August 2022, I conducted an initial inspection and observed the property to be in violation. On 1 November 2022, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance listed above. On 1 November 2022, a compliance inspection was conducted with little change to the property. I have not had contact with the property owner, but have spoken to Mr. James here numerous times. As of my final inspection on 20 December 2022, the property remains in violation. Land Development Director Joanna Coutu.
This is a residential lot, CLR MH, zone for mobile homes. They do not own an abutting lot, so we don't have to do unity of title talk. He's cleaned it up quite a bit. There's still a shed there.
Oh, there's still a shed. There is
Right.
still an offending item, so to
Yes.
speak. Is it? Do you know if it's portable or if it's?
It's pretty large.
It's a large.
Yeah, it's
Okay.
not one
All right.
pickup truck or something.
Okay. Mr. James, as a member of the public, I'd like to get your feedback on this. What's going on?
Okay, all due respect to everybody, when we purchased the property, we never saw this fellow, nor none of these restrictions. We were not made abreast of them until after purchasing the property and setting the items there. That being said, since we were made abreast of it, I live in North Carolina full-time. My partner lives in the Orlando area full-time, and he runs a full-time business. This whole deal was just supposed to be put our hunting and fishing gear here. We come here to go scalloping, clamming, fishing, hunting. So, we thought we were just, let me also say that when we bought the property, the documents we were shown said that the property was listed as rural unincorporated land. So when we looked online, what we saw and what we thought was we were able to park our own personal properties on there. We never intended to stay or even stay the night. Okay. That being said, we received notice. At the time of the notice, there was tremendous amount, as you see, items on the property. Since then, I have done everything I could to move everything I could to other facilities and storage places, or just in the case of the shed, back on, let me just quote the exact date. In the case of the shed, once we realized we were in trouble here and we had to get some of this stuff off, on November 21st, we donated the shed to Scooter Haven, a local nonprofit organization. Mr. Lou Falco is the owner of that, or is the
It's
head
the
of
shed
that.
that they were talking about has been donated.
This is that shed, right?
But it's there.
It is on the property currently. We agreed to donate it back in November to Scooter Haven as in a way to get it off the property and alleviate the situation.
Hoping that they would take it?
Well, no, they have agreed to take it. And back in November, they said they were sending transporter.
Okay.
A transporter did come at one time, but there was a window unit in the shed and they didn't have keys. So they couldn't transport it because it made it too wide.
I see.
Excuse me. So I've come back to town. I removed the window unit and I've called Scully's Towing. They set up a date with me for the 20th. I explained the size and dimensions of the shed. They told me they could do it. On the 20th, they came to do it, but the truck they sent was not adequate to do it.
Okay.
Right. So now I have a new date, which is for Friday morning, and that is with Old Town Towing and Clearing, and that will get rid of the last item. And we have had 2 companies come to move it, as you can see in the photo.
Oh yeah, this happens.
Right, right. So we are trying our best. There was 190 items, just counting trucks and cars
I
as
don't
one
deny
item.
that.
And we have moved 189 of them. And if not for the companies telling us they could do it and not doing it, it would have been done prior to this date.
Yeah, the thing about laws is that they exist and we're all responsible for them, whether we've read them ahead of time or not. You know, I don't remember when I was in elementary school or middle school or high school ever being taught about which specific statute prohibited murder, but I knew I wasn't allowed to do it. These are not murder laws, but my point is that there's no obligation for someone to tell you what you can and cannot do with your property before,
Totally understood.
you got to do
And
the
that-
due diligence. But I think you told me that for the point that it's not like y'all intended on violating the law. And no
we
one
had
thinks.
no idea, and as of
Yeah.
the time we were made aware of it, we have done everything we can to
Right.
make corrective actions. I live in another state, so this has
Yeah.
been at a tremendous expense, and I don't want to, you know, I certainly don't want to throw out the pity card, but this was the motorhome they asked me to move.
Yeah.
This is it 2 days ago. It burned down while I'm here trying to do this. I'm in a tremendous financial peril at the moment. I've done everything I possibly can.
Well, let me ask you this. So it sounds like you've got the solution, but let's say that this truck can't get it either. You never know.
Right.
How much time do you want to be able to fix this?
If we could just get a continuance for 60 days, it will be totally done by then.
I'm not going to do a continuance. What I'm going to do is I'm going to grant you enough time to fix it. And so you're asking for 60 days?
Yes.
Yeah, okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask that the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Actually, Mr. James brings up a decent point. Would the county does the county have a preference as to whether or not I issue an order finding the property in violation, giving 60 days from today to fix it, or continuing the hearing 60 days, finding that there's a violation, but continuing it 60 days as he asked, requiring that that the owner continues to make substantial efforts, and that if progress doesn't take place, if it's not fixed within the 60 days, that the fine is retroactive. Yeah.
There's a process for requesting a continuance, and it has to be done before the hearing.
Right.
The request needs to be made of the director, and in this case, it doesn't appear that a continuance was requested. They do have an opportunity to come to you and ask for a continuance.
And that's
The
what I'm
owner's
doing.
not-
Well, that's what he did. Oh, the owner did. Yeah, right. You know, the thing about quasi-judicial hearings is it's just not as formal, but I do think that rule probably serves a purpose.
May I say one thing, sir?
Sure.
If there's punishment to be had or handed down or guilt to be had, I'm here now and I will accept any finding or guilt in my own name.
No, you won't. Not under our code. So what I'm going to do is I will find the property in violation. I'll grant 60 days from today, which was asked for, to abate the violation. It sounds like it'll be done in 2, but
Yes, sir.
we'll grant 60.
Yes, sir.
If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and constitute a lien on the real or personal property of Mr. Quarles. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Also, just for the record, you know, I don't know if you know this, but these hearings do go on YouTube, so Mr. Quarles can review and see that you adequately represented him at the hearing, and so can everyone else. So,
Thank you, sir.
all right, thanks.
Thank you.
Sir, I would just like to say something, if it's okay. Just not in regards to the case, just something to you directly. I'm here today and all that stuff. I think that it's in 2022 highly insensitive to be titled as a master in America, especially when there are black people and brown people that come up here at all the time. Just my thoughts on the situation.
I think that's fair. I've actually thought about it. Most of these positions are called special magistrates. However, when you look up the word master in the dictionary, there's not that connotation. Nonetheless, that's for the county to take up.
Sure. Sure, and I meant that with
if-
no disrespect at all. It was something that
I
was on
don't
my
take
mind,
it with
you know,
any,
to answer
but
to another man
if
at
you
Master
do,
just
if you
seemed-
do want to change it, you need to let the Board of County Commissioners know, and they have the power to do that.
Yes, sir.
Thanks.
Thank you for your time.
Next case on the day's agenda, Carolyn and Patricia Rose, case number 217-4048, Code Officer Brandon Norman, page 30 of your agenda. Expert on the case, Joanna Coutu.
Good morning.
Good morning. There's one thing I would like to say before we get going.
I need you to be sworn in.
Is, Mom, she's the owner, correct?
Yes, she is.
Okay.
Do you swear to tell, please raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your name, ma'am? And your name, sir?
Jacob Rose.
Thank you.
And what is your position on whether the term special master is appropriate for 2022?
I
I don't know. I'm interested. So, anyways, what did you want to?
If there's anybody that's not part of this case, can they please leave the courtroom, because there's a few things I would like to say that doesn't need to be broadcasted.
It's
through the-
interesting you bring that up, and so the law is that no, that is not even possible. You can ask, and so what you can do. The reason is that we have what's called we have a public records law. This is a public hearing. So think about this. Like I just said, not only do we have to let anyone from the public stay here if they want to stay, this is going on YouTube. So
and I respectfully ask for it not to go on YouTube.
it would be illegal for us to do that. I can't.
You're not understanding the point.
Okay.
There's a few things over my head that does not need to be broadcast on YouTube.
Well, then your choice is to not say them.
Right, and that's what I was going to say. I think I know where you're going, being just history of the case, but you don't have to state that. You can state everything else, but you don't have to state your personal. Okay? I'm sorry.
Okay. So, are you Mr. Rose? Is that
Yes.
Okay. What's your first name?
Jacob.
Jacob. I want to handle things with sensitivity if I can, but I can't close the hearing.
Right.
So I'll leave it to y'all to handle this among yourselves if there's sensitive information that shouldn't be coming out. But I do want to hear the county's case.
Understood. Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-4048, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code, Section 3102A. The address in question is 3566 South Oakdale Terrace, Inverness, Florida, 34452. Property owner is Rose Carolyn and Rose Patricia. I have good service via posted at the property in Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during my initial inspection on October 5th, 2022, and my corrective action inspection on November 4th, 2022, and photos from my final inspection on December 20th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit I completed, and photo of the posted notice of hearing of the property.
Ma'am and sir, I'd like to ask you to look through these documents and let me know if you have any objections to them being evidence in this hearing. And take your time. Am I going to hear boat dock violations today? Okay. I mean, is it on this agenda? Is it?
No.
Oh,
No.
okay.
Separate division.
You're hiding it from me.
No, it's not ours. It's Parks and Rec.
Someone's hiding it from me.
Yes, someone has.
Is anyone here from Parks and Rec?
They were here before.
Can I request an agenda?
Yeah.
I mean,
But I don't know.
I can, I'll get you.
They have a printout.
It's hard to have a public meeting without an agenda. Oh, what did you say? To all the attorneys who are watching this,
There's dozens and dozens.
yeah, right, in my mind. All right. Sir and ma'am, did you have any objections to these
No,
documents? Okay, then without objection, what's been proposed as exhibits A and B are evidence.
Okay, on October 5th, 2022, an initial inspection was conducted of the property for an RV on a vacant lot. The property was found to be in violation of the above ordinance. The property remained in violation of my notice of violation corrective action inspection on November 4th, 2022, as well as my pre-hearing inspection conducted on December 20th, 2022. I was able to make contact with the property owner. She has been very polite and respectful, and I've explained to her the process of what needs to happen and how to abate the violation. But in the meantime, her grandson, Mr. Jacob Rose, who has admitted to living in the RV, has been hostile and aggressive towards two of our code compliance officers, including myself. He insists that his grandmother's RV is allowed to be on her vacant lot even after being explained to several times.
Okay, you said that you explained what it would take to abate the violation, I believe, to Miss Rose.
Mm-hmm.
And what did you say it would take
To remove the RV from the lot.
to remove the RV?
Yeah.
Is this a unity of title situation? I mean, I'm looking at the photos and I don't know.
Rewind and repeat in this one. There's a house next door.
There is a
So
is it owned by
Yes,
Miss
Miss
Rose?
Rose has, she has another vacant lot too, but that's not part of this. So yes, so technically she could remove the RV, move the RV back to the house lot, or yes, build a structure with permits to house all of this.
Okay.
Yes, so three options, I guess.
Thank you.
If I can, sir.
Yeah.
We run into the other issue where if they do that, we'll run into another violation where there'll still be someone occupying that RV.
That's not
regardless.
before me. But I do want to know.
I just said
mean,
that's why when
I hear you.
informed her, it was just to remove the RV from the lot.
I hear you. Okay. Is what the county said made sense to y'all?
Do you understand?
Well, let me be more clear. I mean, did you understand everything the county just said, Miss Rose?
Said that I was in violation letting the RV stay there.
Correct. Because on this lot, in order to have the RV and almost really to do anything on this lot, as a precondition to that, you have to have a principal structure there, like a house, in order to make that lot usable, in order to have the accessory structures there. Most of the time, what was the testimony we just got, though, is that there are things you could do that might work on the property, but as it is, it either has to be moved or you have to go through a permit process. Does that make sense?
Now, I can't move it because of some circumstances that I have going on, and I only have to be in certain areas. And the sheriff's department, and that's all I'm going to say,
I understand.
is very clear that I can stay there. And I'm away from everything.
Right.
Now, I'm asking for 5 years. That's all I'm asking for is 5 years so I can get back up on my feet. I lost my check. I was evicted from my old place. I had an actual house over in Hernando, and then he moved his stepson back in. And it was just like all at once. So like I said, I'm asking for 5 years just to stay there so I can get back on my feet, get my check back. I am working with my cousin. We are doing lawn care, but as you know, it's the wintertime, so nothing's really...
You own the RV?
She does.
She does, okay. Okay. I'm thinking through the issues.
And no RV park or travel trailer park is gonna accept me
Okay.
at all. I already tried.
The issue here is that I'll tell you, you have to make the ask, and I appreciate that. 5 years is I've never done anything remotely that far. It doesn't mean I can't, although I suspect there probably is a limit to my authority to go that far. Is there a limit on my authority?
Not today. I think it would have to be something that would be reasonable, and I don't see
Yeah, I mean, the county would be in the position of appealing my order. Yeah.
there's no evidence that
No, I'm just curious.
on the county's part, the county attorney's office, we would state there's not been any evidence presented that would justify it.
Yeah, such a departure from my previous orders. The reality is this RV is, you do have methods of fixing it. There are things you could do to allow the RV to stay there. You could build a house. You could do some kind of other structure that's permitted by the county. So it's not necessarily the case that it would have to be removed. But yeah, I don't know.
There's no provision that allows a person to live in an RV.
Beyond 2 weeks or something at a time. So in essence, Mr. Rose, whether we like it or not, this is what you've discussed is what you're basically asking me to do as a special master is to ratify a separate violation because they can come at you with a violation right now for living in the RV. I don't see it. It's not in front of me.
But I've looked it up online, and it says nowhere online that you have to stay in there for 14 days. You can stay in there 365 days a year.
No, it does. So, do you guys know this section offhand? I just like people to know, but
This is for storage on the
Temporary uses, so it's right where you are in chapter 3, the beginning.
3 and
Temporary uses, and it says developed property, so this isn't developed anyway, so even the 14 days is not an option. I can approach if you need to.
Okay, so
It's page 3-5,
3-5. Okay.
table, and it's table 3-1.
Okay, thank you. So, table 3-1 is titled Temporary Uses That Require Approval of a Permit.
I apologize, 3-2.
It's the next one.
Yes,
yeah,
I apologize.
that's what I thought. Okay, so table 3-2, temporary uses that can occur without a permit, and let's see, temporary occupancy of a recreational vehicle on improved property, 2 weeks per address per year, and that's designed, I presume, to allow guests to come and stay. But that's on improved property, and this lot is not improved property. Now, I don't know if that changes if you have unity of title, but it's really irrelevant because you're staying there longer than 2 weeks. So I cannot give 5 years to commit an ongoing code violation. You've heard that in similar cases today, I've given sometimes ample amounts of time to resolve this issue. How much time would you need to fix the violation?
Well, I am fighting Social Security, and I don't know how long that is going to take. It is the holidays, and I do have some paperwork in. I did talk to, I had an appointment with Social Security on the phone with November 30th to reapply, and I don't know how long that's going to be. And if I get denied, I'm going to have to get a lawyer, and that could take up to 2 years before I even get it back. That's why I said I needed, yeah, I know 5 years is kind of extreme.
Yeah.
Is there any way I can get 3 years? That's all I'm asking for to, get back on my feet. That's all I'm asking for. And we've been looking for like a mobile home to put on there or even a tiny home.
The reason why I can't do that is because I would be preventing the county from enforcing its own laws. In other words, the case is not in front of me today, but they have a right to bring the case regarding the RV issue. And if I issue that order, I think it's illegal, frankly, because I am preventing them from enforcing a whole separate law. So I can't do it. Not on that ground, at the very least. And so what I need to know, and Ms. Rose, I guess I have to ask for the record, Are you allowing Mr. Jacob Rose to speak for you? Or are you here in two independent capacities?
Well, I'm just going whatever to find out what's going on.
Well, you're the person in charge of the property. So you're actually the person who's going to suffer any penalty that I assess.
Understand that.
Okay, all right. That's why I just want to, I do want to hear what Mr. Rose has to say, but I just have to know if he's speaking on your behalf or if he's just speaking on his behalf.
On my behalf.
Okay, fair enough. So what I'm inclined to do is, Ms. Rose, let me ask you. I mean, look, if you have to move this thing, where would you put it? Okay. And you are not going to build on the property?
Not right now. I don't have money to do anything.
Okay.
I spent all the money getting the
Sure.
RV for him and moving out all his other stuff.
Okay.
And he's got stuff in storage that he has to pay.
Look, what I'm going to do is I'm going to grant you an amount of time to fix the violation. And you can either move the thing off the property or you can do something to the property that makes it okay to keep the RV there. In other cases today, I've granted between 3 and 6 months. So how much time do you need?
Can we at least get 6 months? I mean, can we at least build a carport over it and still stay in it? Or
Well, Mr. Rose, here's the key. No matter what order I issue, it's not going to make it okay to live there. And you've confessed to another county violation.
The thing is, you are not understanding what I have to go through. I have very, very strict rules I have to follow.
You
And
might be
that's-
surprised. I actually do understand. And what you don't understand is that the laws apply equally to everybody. So,
But the sheriff's department has no problem with it.
Is the sheriff's department Citrus County code compliance? Do they know these county, are they telling you, are they giving you an analysis of these code sections? The answer is no. They're looking at it from a criminal perspective. So I get why they're saying that. They have a different need with you, okay, than we do. All right? Now, what's the county's recommendation?
Citrus County Code Compliant Division respectfully requests that the Special Master assess a fine of $100 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and respondents' actions relative to this violation. We would also ask that the Special Master additionally find that this is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Ms. Rose, you are clearly a caring and generous person and grandmother. It is Christmas, and so what I'll do is I'll grant the 66 months that have been requested to fix the RV violation. That's, the max that we've given anybody to kind of fix this type of issue, based on the fact that you're not going to build on it, all right? Because really all it takes is moving the RV. I'm going to find that the property is in violation. There will be a fine of $100 per day if it's not brought into compliance as ordered. This does nothing to fix the ongoing violation on the property regarding living in the RV, which will also end up being a violation on your part, Ms. Rose. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording if it gets to that point, which would be about 9 months from now. And the property owner, you, Ms. Rose, would be responsible to pay all costs required by county law.
So in other words, he has to move the RV within a certain time.
You guys, you are responsible for the RV being either moved or that you take some other measure to abate the violation, which would be putting a house, a properly permitted house, or something else that satisfies the county.
What about a tiny home or
I don't know
a
the
mobile
answer.
home?
That I don't know the answer to. That'll be for outside the hearing and the discussion you need to have with the county. And I encourage you to have it. Thank you.
Thank you.
I apologize. I'm going to reopen the hearing. Is there anyone from the public who wishes to be heard on this case? I didn't ask for members of the public, and that's something I should do.
And I do have one other question. The name that came off of the complaint was Sarah Parker, who lives in Floral City. Now, why would they drive all the way from Floral City, all the way to Inverness, knowing where I live, to make a complaint?
The hearing is closed. Thank you.
Thank you, sir.
Next two cases on the agenda, Christopher M. and Denise A. Temple, case numbers 217-4650 and case number 217-4649. Code Officer Amy Becker, pages 33 and 34 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, sir?
Chris Temple.
Thank you.
Good morning.
Morning.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-4650, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41, and case number 217-4649, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address for both cases is 1933 West Albury Place, Citrus Springs, Florida. The property owner is Christopher M. Temple and Denise A. Temple. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence for both case 217-4649 and 217-4650. Exhibit A. Photos taken during my initial inspection on October 14th, 2022. Photos taken on November 8th at my corrective action inspection. Photos taken on December 6th showing the posting of the property. And photos taken on my final inspection December 20th. Exhibit B. A copy of the notice of violations, a copy of the notice of hearings, and a copy of the posting affidavits.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing. Ms. Becker, are these the same exhibits for each case? No. Okay.
No, I don't. I just have two of these three pictures, questions about them, but I'll listen to the case first and
Yeah,
see
and
what
you have,
happens. And then we'll come
absolutely,
back
and you'll
to
have
it.
the right to ask those questions. Is there anyone from the public who's going to want to be heard on this case? All right, I see no response.
This is the vehicle case. You know, look at these.
The vehicle case? No. Trailer's tagged. Everything's tagged.
Okay. Let me just have a moment to look real quick. Okay. Okay.
Okay. On October 14th, I conducted my initial inspection for accumulation of junk and debris and observed a tire, some trusses, and other debris, which is a clear violation of the ordinance listed above. And also, as far as initial inspection for abandoned, unserviceable, and unlicensed vehicles, I observed a trailer in the front yard with no tag and a yellow vet with an expired tag, 2 other vehicles that I was unable to view. I have met with the owner of the property. He's aware of the violation. Progress has been made as far as the junkyard conditions.
Okay. Just a little bit out of order, so I'm trying to figure out. Aha. Okay. What was the response? I mean, has he worked with you?
Yes,
Yeah,
he's
okay.
been very cordial. He has worked with me. He's so close as far as the junkyard conditions. He's very close to compliance.
Okay.
There's still a white appliance. If you look at the pictures on the 20th, there's still a white appliance in the back, and there's some trusses. He's been burning the wood, so it is getting cleaned up. He just has a little bit ways to go.
It does look substantially better.
Yes.
And so some of the wood you're not considering part of the junkyard conditions because it's actually like being used?
The
or-
trusses are going to be junkyard conditions because they're molded. There's construction debris that is no longer. I see what he's doing as far as the building with the other wood that's there, and that's fine.
Okay.
He's obviously building something,
Okay.
and that's fine. But I need the piles of.
Okay.
You can see there's a couple of piles that are debris that are still there.
Okay. I'm looking at the photos from yesterday, and I just want to make sure I understand what you're saying is necessary to bring it into compliance. It does look like there's still some debris beyond the white appliance.
Yes, there's a pile under the white appliance.
Is
There's
it
a-
your position that that all needs to be cleaned up?
Yes.
And on the unlicensed vehicle, I think we heard Mr. Temple say that there are no more issues. I don't know if I misunderstood.
The blue and the pictures taken from yesterday on the 20th, the blue Chevy, the vintage blue Chevy, is on a jack and blocks, so that would be considered inoperable.
So if it wasn't on a jack and blocks, you'd consider it operable?
There's no jack.
Okay.
There's a.
Is it on blocks?
Yes, sir.
Okay.
The
Because
jack's in the
it
picture.
has airbags on it and it weathers the airbags. You take the pressure off the airbags when you're storing the vehicle, it won't dry rot the airbags. All 4 tires have air ride system. I push a button, it goes down. Push another button, it comes up. 'Cause
Well, I want to make sure so I see a jack there, but I can't tell if it's on the jack.
it's not, it's beside it.
Okay. And I see the blocks. Is that related to the system you're talking about?
Yes, sir. You put the blocks up on there, take the pressure off the wheels, the weight off the vehicle. It saves the airbag system because they're like the size of.
I understand. So you're saying it's something that is peculiar to this car that you need to keep it on the blocks?
Yes, sir. And also, may I state that those vehicles are tagged and licensed, although they are outdated a few years, the tags, they are in a legal battle right now.
What's the legal battle?
Probate.
Probate. Oh, the cars.
Yes,
So
sir. Supposedly probate, but that's what the issue is. Is it probate or is this blah, blah, blah?
Okay.
And that is 5 hours away from here. That is in Lee County, Florida. What's that? And I can move them, but I'll get in trouble. If I do anything to them, I'll get in trouble, they say, but who knows?
It may
what.
take you 5 hours in that Cadillac, but I don't know if it takes 5 hours in a regular car these days.
To Lee County?
Yeah.
Wow.
Maybe
Fort Myers.
Maybe I'm doing something wrong. Well, let me review the code section on inoperable vehicles because I want to understand.
I'll take the blocks out from
Well,
them
here's
if
what
I
it
have
says in section 20-41. It says, it shall be a violation of this article for any person, firm, or corporation to keep, dump, store, place, or deposit abandoned, unlicensed, inoperable, junk disabled, or otherwise unused vehicles, or vehicles without a valid registration or tag. Yep. All right. So how much time do you need to fix that?
I'm hoping, may I have, according to the courts in Lee County, it could be up to 6 months to a year before this probate issue is over with.
Meaning you can't get a valid tag on it until the ownership is resolved in a probate?
My wife is AFib. She just had open heart surgery, and I have to go to Oklahoma to do this. They were registered out there. My wife is from there. We brought everything home to here. I have to go fly out there, leave my wife unattended, and that's not good. She had open heart AFib surgery. They replaced it anyways. She can't travel.
I don't believe that you have to go to Oklahoma to register a car here.
Because it is out of date paperwork, and they said I still went down here to look down the road. They said I had to go to Oklahoma. I had to go to Oklahoma and do this.
Okay.
And I don't have that time and that money right now.
Okay. How much time do you need to fix the junkyard conditions?
Due to my wife's situation, and I'm a one-man band, I do everything. I get 4 months, if that. I mean, shoot, give me 3 months.
You made remarkable progress in 2 months. I agree. There's really not that much to do.
I have 2 months.
Yeah.
Thank you. On the debris.
Right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day for each case, along with administrative costs to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for re-inspections.
Ms. Baker, how many vehicles are you claiming are subject to this case? Is it just the Cadillac or?
It's the 57 Chevy Bel Air and the 77 Corvette Stingray.
Okay, and that's the yellow one?
Oh, the yellow one I do not own anymore, sir. As of, I might have to go repossess it today, but right now it is not on my lot.
Okay.
I sold it.
Okay.
There's a gold, there was two vets, so there
Okay.
was a yellow one and a gold one.
All right, I see
So
that.
the gold
is
and
the
the Chevy,
77
the
Stingray.
vintage Chevy.
Okay.
The 88 yellow is sold.
I'm just looking up Oklahoma vehicle registration real quick.
They're cheap, $1.50 to go out there.
Well, here, you can renew online, and I'm just interested in if you can do that here. It appears that.
Sir, there's a death. It was registered to my wife and her ex-husband, and it stayed in both names. He died. We have the paperwork for that. And I was told that due to the death, That is the reason why I have to go to Oklahoma in person to do that. And I'm like, well, paperwork's paperwork. What's the difference between a driver's license and a death certificate? You're looking at, well, that's just the way it was. I might have weed in her Cheerios that day. I don't know.
Okay. Yeah, it doesn't. See, I mean, maybe what you're thinking is in order to get the registration current and to put it in someone else's name, you'd have to go there.
That's what it is, because we're taking it
Okay.
out of two names,
Right.
Denise's name and his name, and he passed away, and it's going to me.
Right. Okay.
And
but
I have power of attorney
my
on
point
that.
is that it doesn't actually require that to get a current tag, even though it wouldn't be in your name, if that makes sense. But that would take you out of the violation.
Say that again, sir, please.
Your violation here is not that the vehicle isn't in your name.
Right.
The violation is that it doesn't have a valid tag. Okay. So what I'll do is, in each case, let's go through this. In both cases, I'll find that the property is in violation. In the case on the junkyard conditions, which is case number 217-4649, we'll grant 60 days from today to abate the violation. And on case number 217-4650, we'll grant 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, in either case, a penalty of $50 per day will be imposed. That's independent. In other words, each violation would be $50 per day, if not fixed in the time allotted. This fine would be recorded and would constitute a lien on the real or personal property of the Temples. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Thank you.
Okay, I have a question here. What do you get for those laws?
Yeah.
Next case on the day's agenda, Sabra and Portwood, case number 217-6879. Code Officer Alan Jonason, page 28 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Sabra and Portwood.
Thank you.
Good morning.
Morning.
Good morning, Alan Jonason, Citrus County Code Compliance Officer. This is a repeat violation initially observed on 4 March 2022. The address of the violation is 3255 East Deal Street, Inverness, Florida. This is case number 217-6879, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner, Portwood Sabra Ann, has been previously found guilty of the same violation at the same location on 19 May 2022, which was case number 215-9794.
Oh,
with
hold on. Well,
it's the dates. I don't know whether to go by the dates that he's got on the paperwork or the dates that he's actually stating now.
okay, I'll get into that. Please proceed.
On 19 May 2022, case number 215-9794 with $0 in imposed fines. That case was abated on 20 June 2022.
I do want to ask you about that. So, it abated in the time allotted.
It abated the day
Okay,
after.
so no,
Yes, sir.
Okay.
I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts in order acknowledging compliance from previous case 215-9794. Exhibit B, photos I took during my initial inspection on 21 November 2022 and photos I took during subsequent inspections on 16, 13, and 20 December 2022. And Exhibit C, a copy of the notice of violation and copy of notice of hearing sent to Portwood Sabra Ann, and a copy of the posting affidavit and a photo of the notice of hearing posted on the property.
Is it Sabra or Sabra? Okay, Sabra. I'm going to get into your date question. I want to handle that once I turn the case over to you. In the meantime, I want to ask you to look through these documents and let me know if you have any objection to them being evidence.
just have a question to the dates.
Okay,
Not
well,
like the
then
dates
let's
really
take it up.
matter anyway.
If it affects your objections, so your question is, do you rely on the dates that he's saying or the dates in the paperwork, correct?
Well, this paperwork says 22, this paperwork says 21.
Do you mean 2021?
Mhm.
Okay,
That's-
sounds like it's a Scrivener's error, but we'll get it. I mean,
So, I can't remember. It's been a bad year.
yeah,
I don't know if it was actually last year, if it was actually this year.
well, we'll find out.
And so, because I go by this paper that he left, it
Yeah.
says 2021. Now you're reading this paper, it says 2022.
I don't think it matters, to be honest.
Exactly.
Yeah, but we'll get
But
into
at
it.
least have it a little bit, I don't know. So anyway. So, I guess I have an objection to some of these photos being admitted.
Mhm.
Not that it matters.
It might. It might. I mean, what's the basis for the objection?
Well, yeah, they didn't actually word accumulated this time. It was technically a delivery that I had, and because I don't really see anything wrong with these pictures in November.
You mean the junk that's showed in the photos? You're objecting to it as being yours, that it's some kind of delivery or something.
Yes, it's delivery of what I don't.
Well,
I don't
that's-
see. You
so,
can
Ms.
look at the pictures.
Portwood,
I
the
don't
deal with
see
that-
junk in here.
The deal with that, Ms. Portwood, is that it's not really an objection to the photos because
Right.
you're not really disputing the authenticity of the photos. You're saying the photos don't support the county's case; they support yours. So that's fine, and you're entitled to that, and I want to hear that opinion. But it's not really a substantive objection to the photos.
Okay.
So I guess it didn't matter. I'm just. But we, you know, there's not that many rules in these types of hearings, Ms. Portwood. But one of the key ones is that you have a right to lay the record that you want. So I do want to hear what you have to say. It's this crazy thing called due process.
There's more crazier than that. We'll get into that. We've been into that last time. That's why I wasn't coming back here.
Well, I remember. It's kind of like night court when you see the same person.
My court just got better, okay, because I've learned something, and I've learned something else today, just sitting here through all these other ones. You can't even replace your own broken window. I guess that brings back painful memories that I did have a county inspection done of someone's certified electrician's work, which should not have passed inspection. And because I replaced a 13-cent screw, a week later, it would have been covered under the initial. I get double fined, So, yeah. It's just, and this would be another question.
There's a rule for everything.
I don't even know the rule for this.
Yeah, so
I don't understand why I get it mailed to a different town 3 weeks before it gets posted on the property. I have a little bit of an issue with
well,
that.
I will explain that when I go through the evidence as well. Because I suspect it's in the evidence that explains why. That's the other thing. So one of the very few other rules that we have in these types of hearings, besides due process and you getting to lay your record, is notice. So it's very, very important that we establish some method for you having notice of the hearing. Sometimes mail is insufficient, and then
All right, this paperwork just serves as a notice for hearing, not a notice that you have this problem against you.
it may be both, but that's the point, is that at every step you need to have some kind of notice of what's going on. And that's why sometimes mail is insufficient, so then you do a posting. But in any event, let me look through this very briefly, and then I'll hear what else the county has to say. a lot of photos, so let me just want to make sure I understand everything. Mr. Jennison, when did you first have contact with Ms. Portwood on this case?
Yesterday.
Okay.
I know he's aggravated, sir, because the neighbors call every month. He's out to my house taking pictures. He was just there 6 to 8 weeks before that saying, you get calls about your truck and your trailers, junkyard conditions. You're not in violation, but I'm going to go ahead and take these pictures. So I know he gets calls and he knows he's coming out on a regular basis.
Yeah, someone's watching you.
Yeah, they are. And so I don't let anything sit for 48 hours, because that's kind of like the number I got from y'all the last time I was here. I should have 48 hours to do something with whatever it is that I'm working with. So I try to have everything moved that I bring in or whatever within 48 hours. I mean, I'm paying the county $185 a month in taxes to stay on my own property. I should be able to exist on it to some degree, but I think not, so I probably have to sell. So,
Okay, so let's talk about one of your first object. I do want to hear from the county, but you had asked about the dates. So it's a Scrivener's error. It shouldn't be 2021, it should be 2022, but it does give the case number, and I'm looking at the case documents, so it really doesn't affect this
okay,
case.
that's fine.
But, I mean, it's a fair point. And what I'm going to do is look at the, let's see. Okay, so as I suspected, we have in Exhibit C, page 3 of 4, an affidavit of Alan Jonasson. Here's what it says, because this will answer your other question. I have attempted to serve a notice of hearing regarding an alleged code compliance violation upon Portwood Sabra Ann at 304 Bowers Street West, Perry, Florida, and met with negative results. Due to the inability to serve the notice of hearing via certified mail or hand delivery.
He went hand delivered 125 miles.
No, it says via certified mail or hand delivery.
Okay.
On December 6, 2022, I posted a copy of the notice of hearing upon the subject property. And that's for your benefit. It's so that you know that there's going to be a hearing, and they're allowed to do that. So I have a photo of it. Anyways, what's the county's case?
I conducted my initial inspection on 21 November 2022 and observed that the property was in violation of junkyard conditions. During subsequent inspections on 6, 13, and 20 December, I observed very little change to the property. I received contact from the property owner yesterday, but as of my final inspection on 20 December 2022, the property remains in violation. What's happening with the tree debris, that I guess it's a tree service, they do tree work, they bring in tree debris. You can see that in one of the pictures, it's on the left-hand side and then it's gone the next time, whatever. But there's other junk and debris throughout the property as well.
So the tree debris doesn't bother you because they're generally.
No, it does bother me.
Okay.
Absolutely.
Okay.
Absolutely.
Well, let me look into that then.
It doesn't usually bother him when I place it directly behind the house. And so it's turned into mulch.
I didn't notice the tree debris, so I'm trying
It's in the very first picture.
It's in the very first picture.
Yes, it's behind the chain link fence.
Oh, that's debris.
Yeah,
Okay.
see, you know, you don't know.
I thought it was overgrown grass.
Thank you.
So,
It's overgrown bushes, actually. Those are not trees, debris, but
okay.
I cut them down after that first picture, as you can tell, because then they're not there. And then I replant them back, and never mind. So.
Yeah. All right. So I now understand the tree debris issue.
It doesn't usually get placed in that position because, heaven forbid, I lay something for an hour, the neighbor comes and blocks me from accessing my property. He's taking pictures of my yard.
I wish I had a photo of it when it came into compliance, you know, just so that I could see what it looked like. But
Look at the next picture.
Let's talk about everything that the county considers a violation here. It looks to me like there's a lot of stuff in a back porch or something.
There
that's
is on a side. There on a side porch. There's a lot of items there. There's tarps. There's tires. There's a truck toolbox.
That's what that is. Okay.
There's
No, wait a minute. If you're talking under the
auto
car
parts
part,
out there.
not
There's
truck
planter pots that are strewn all over the property.
Well, planter pots. I mean,
They're not strewn all over the property.
Well, they're not being used for their intended purpose.
They were not on their purchase because of the window stuff, so they were on the ground. And now this
Oh,
morning they're back on their
Ms.
purchase.
Portwood, I want to give you the opportunity to lay the record, but you may be doing yourself a disservice by
Yes, sir.
saying too much about it because I want to look up the code section. I might be able to draw the line at pots, but maybe not. Maybe it is debris. You usually do keep those outside, but they can be stored in a shed. So
The stuff that he just mentioned was the same stuff that was mentioned in the last case, which was approved, which has been sitting there since the last time that it was approved. My 5 tires on
that's
the
what I
rim
wanted to know. So when the
have
property
been
was
approved the last time
when the
on
property
this case.
was brought into compliance, what from these photos was actually there?
The tires, the toolbox, which is it says tool storage container meant for outside. But now I learned as of yesterday that because it was also designed to fit in the back of the truck, now I'm being told that I must have it on a vehicle, and I just don't see that. And it's been there since the last code compliance. All this stuff has been sitting in the same exact spot that it was when it was in compliance the last time.
All right, so so here's the definition of junk. Any abandoned property, construction or demolition debris, litter, waste materials of any kind, used or unserviceable automobile or machinery parts, used or non-functional furniture or appliances, used or non-functional tools, equipment, and implements, but shall not include compost piles for normal, personal, etc., etc. And then you have a definition of debris, which is material which is stored externally, exposed to the elements, and is not otherwise completely enclosed by a walled roof structure, and shall include, but is not limited to the following: discarded household items, inoperative machinery, appliances, refuse, rubbish, trash or junk, scrap or discarded lumber, pipe, steel, plastic, glass, paper, cardboard, plumbing fixtures, and other building material. The issue with the toolbox is that it looks like it's meant for a truck bed. So it's not, it is kind of what I think would be under used or unserviceable automobile or machinery parts. Even though it might have a use and it might be very, useful to have out there. What I'm interested to know and what I need to know from you, and then I'm going to talk to Mr. Jonason, is what was there at the time the property was brought into compliance? So
Same toolbox. Sorry.
that toolbox, okay.
Same location
The tires?
as it was. The tires are the same, in the same location.
What about the pots?
Same location.
Were those
same
there?
pots. Yes, they were.
In May?
Yes, they were.
Okay. What about all these chairs in the back?
Same chairs.
And the tarp?
Same tarp.
What about all the stuff piled up underneath the porch?
Only thing difference underneath that area is all the same except for they are cabinets that will go up in that area.
I remember this, and Mr. Johnson, I thought I determined that was a violation.
You did.
Last time.
Yes, sir.
Okay. And what did she do in order to bring the property in compliance here?
Those items were removed.
Were gone?
Yes, sir.
Okay. I remember, I mean, if somehow that was determined to be compliance from your perspective, I would have been surprised because I know we determined that was a violation at the last hearing. What she has said about the toolbox, the tires, the pots, is that true?
No, sir. Not to my recollection. I know there was
There are pictures. Y'all, you have the pictures.
No, hold on. We let you speak. Let's let Mr. Jonas
There was pots out there, but they're not being used for an intended purpose. They're just scattered throughout the property. If they were being used for plants, trees, shrubs, those kinds of things, it wouldn't be an issue. But they're just laying on their side for the most part and strewn about. There's also other junk and debris. In the backyard next to the shed, it appears there's a mattress.
It's
or
not a
something
mattress.
back
It
there.
is a storage unit, once again, that goes on top of a vehicle when you're traveling.
Ms.
to keep
Portwood, with
stuff
all due
dry.
respect, I'm trying to
I'm
hear
sorry.
what Mr. Jonason has to say.
And there's also tree debris on the right side of the property. You can see that as well. And that's also in the last picture as well. It's a couple pieces of like a tree trunk or something that's sitting there.
That was,
I mean,
that
Ms.
was
Porterwood-
also there in
Ms.
the
Porterwood,
final
what
one.
it appears to me is that you got the property into compliance and then brought the stuff back, basically.
No, everything is the same as it was when it was brought into
Well, then
compliance.
one of you is lying about the stuff under the porch.
You may get the pictures from the compliance. You can get the last pictures that he, in this case right here, it'll show that those things are still there.
What is the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin on the date of the posting on the property, which was 6 December 2022, and continue until 20 December 2022. That would be 15 days at $150 per day, totaling $2,250, and a fine of $150 per day from this day forward until the violation is abated. We would also ask that the special master find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Can I object to anything that he just said? Because that's all a lie that he told me yesterday. That there wasn't going to be no fines imposed, that you give me time to clean it up again or whatever, and then, but now the third time, what he said yesterday, on the next violation, I would get a immediate citation and go to court. And I just don't understand it. There's nothing in the yard that is violating, and it's the same stuff that was already okayed at the last one when he cleared it up. The same exact stuff.
Well, I can tell you, I remember the case, and I remember what I saw, and I specifically remember the debris in the porch and saying at the last hearing that it was a violation, because I asked about it.
No, because that, on the left side.
I remember, because what I asked was, is it good enough unless it's enclosed? And so what I was interested in was, so, you know, sometime,
Same as last time, it was a grinding
according
table.
to this code, ma'am, honestly, please.
Okay.
According to the code, if you keep things in an enclosed receptacle or inside a house, that's not going to be a violation. So what I was curious about at the last hearing was whether or not it was sufficient to just have it under the roof, and it's not. And that's part of why I issued the violation. So I know that I have said before that that is a violation.
You said that if it was to be used there, that whole left side is the grinding wheel area and everything where we sharpen all the blades and stuff. That stuff intended use is used there.
You are correct. We
you
did
brought
talk
up
about
the
that.
grill multiple times. The grill was brought up.
I remember
the
that.
grill is there,
remember
and
that.
that's supposed to be acceptable. My neighbor has one. The other neighbor has one. They all have one under their area.
But the standard is not whether everything that's strewn in your yard is being used or not. You're not allowed to just keep things outside. You know,
Right.
I mean, again, we go back to the code section.
What I don't know what items they're saying string because I asked him yesterday. Tell me two things.
Okay, yard debris. We talked about that, plant debris. So that's number one. That's a
No,
violation.
it's not straight all over.
That's a violation in and of itself. Yes, but it's one of many other things that you have spread across the yard. So that's a big one. You asked for examples. There's one. And then, I mean, you have, and I, if you look, I mean, these are some of these cabinets and things. They're not being used. They're outside, not enclosed. We did talk about the refrigerator last time. And I remember asking if the refrigerator was a part of the violation.
And it came back and then it was removed again when I
It didn't. It's
came
been there
back out.
plugged in the entire time. There was a different one. That one was been there and plugged in. And now that it's not summer, I'm not using it, so I took it back up.
Just want to make sure that this is all correct.
No, it was a washer and a dryer that was out there before. The refrigerator was plugged in and operating there.
so the code section's pretty clear. Going back to the definitions again. Junk includes used or non-functional furniture. There's that under the porch. I mean, I'm not going to find that the pots are debris or junk, based on the evidence. Is the tire? It looks like it has a rim in it.
They all have rims.
Is that junk or debris under the code?
Absolutely.
Okay.
That's not what y'all ruled last time. Y'all said if it was on a rim, it was acceptable.
Unserviceable automotive.
That's what I thought too. I thought that.
You spent a lot of time looking at it, researching it last time.
Yeah,
You said
I remember.
I had to get rid of the one tire that was a tire swing because it was not on a rim.
Miss Antrim, that's my memory too.
That's what I remember.
Okay,
yes.
all right. And I'm not going to find that. I see one tire with a rim in it. I don't see others. They may be
There's
there.
actually 5.
I see a few. They all appear to have rims in them.
They all do.
I'm not going to go against my prior holding on that, which I relied on the county for advice on that. But as to the other stuff, Ms. Portwood, I agree. I think this is a junk and debris case.
You want to say the tree stuff, which was there, which was
Vegetative
gone
matter.
within 2 days.
It was gone within 2 days?
It was.
You're saying it's not there now?
If you look at the first picture when it was there, you look at his second picture, it's not there. Now I have another load, and I don't keep it 48 to 72 hours. I process it, and it's gone.
All right, so I'm looking at the November
So it's
21.
like-
Yeah, okay, so I'm looking at the photo from November 21, 2022. I see a bunch of vegetative debris. And now let me see if I can match it up. And it is gone by December 6th.
Yes.
Okay. All right, so I don't find that to be a violation. We're whittling it down.
I mean, he was telling me, you can't keep those, you want to tell me that I can't process the wood to make mulch with it? That's what you're telling me. I mean, is that the law that I can't do that?
I haven't even gotten to that. I don't see, where is that mulch wood or where's the wood?
That's what I do with those branches. They're small, and I tip them up.
Well, look, I already said I'm not finding a violation
Okay.
on the vegetative matter. It does look like it wasn't. I can't tell how long it was there. According to the photos, it was gone at the next time that photos were taken. There is a bunch of junk and debris in that porch.
The only thing that is new in that porch are the cabinets. Because before it was a washer and a dryer, and I told me I couldn't have it, so I moved them inside.
The truck tools thing.
On the left side of the house.
It does satisfy the definition of junk and debris.
Okay, even though it was approved at the last hearing, I have to
I've
remove
never
it.
approved it. I've never approved
Well, the
it,
code enforcement
so-
approved it, said it was in compliance.
Well,
Said it was fine.
whether it is or it isn't, honestly, is not your biggest problem.
Right.
The biggest problem is that I am going to find a repeat violation based on the porch.
On the porch, just for outside cabinets that I just brought in.
For any junk and debris under that, in these photos. So it looks like it certainly includes the cabinets. And I think that's why, I suspect that's probably part of why Mr. Jonas is not asking for a repeat violation from November 21st, but rather from December 6th, because that's when we get into some of these photos. So I've eliminated a lot of the proposed, violation, but there is still some there. And so what I'm going to do is I am going to adopt the county's proposed findings of fact that I have described here, all right? In other words, that I don't find a repeat violation based on the vegetative matter. I don't find a repeat violation based on the potters or the pots or the tires. I do find a repeat violation based on the truck toolkit, as well as the cabinets and any other junk and debris shown in the photos beginning on December 6th. I will not assess a fine of $150 per day based on the whittled and narrowed scope of what the violation is.
I mean, what are you gonna tell me I'm allowed to have it there? That's my son's work stuff. It's on the cabinets. That is
So
where
it's
we work.
important, two things.
You got the jacks
it's really
underneath
important
there.
to look at these definitions. And then number two is, if you're concerned that it's being approved with junk and debris in the yard, take a photo. Introduce it as evidence. Have something for your own records to make sure, because I'll look at it. So what I'm going to do is I'm going to find from the period of December 6th, 2022 to December 20th, 2022, instead of a fine of $150 per day, we'll do $50 per day. And from today's date going forward, it'll also be $50 per day. But it's got to be cleaned up, and it's got to stay that way in the future. So that's what I'm going to find.
Thank you.
Thanks.
Thank you.
Next case on today's agenda, Robert.
I'm sorry.
Marcella. I'm sorry.
I'm sorry, Mr. Charles.
Give her a number of days to clean up, or because
There isn't, because it's a
Because
repeat.
it's a
It's from yep.
just checking.
Next case on today's agenda, Robert Marcella. Case number 2173741, Code Officer Alan Jonason. Page 26 of your agenda. Expert on the case, Jeff Atkins.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2173741. Buildings and Building Regulations, Chapter 18, Article 1, Section 18-8A. Permits, obtain after the fact permits for all construction or modifications of the Citrus County Code of Ordinances. The address of the violation is 3141 East Buffalo Lane, Hernando, Florida. Property owner is Moshella Robert. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos from the building division from 11 April 2022. Photos taken during my initial inspection on 3 October 2022. A screenshot from Hanson reflecting no existing permits from 20 December 2022. And photo from my final inspection conducted on 20 December 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
Is there anyone from the public who's going to want to be heard on this case? Okay, let the record reflect that there is no response. Thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On 3 October 2022, I conducted an initial inspection and observed the property to be in violation. I verified in Hanson that no permits had been issued for the structure. On 3 October 2022, a notice of violation was issued for ATF, which is a violation of the ordinance listed above. On 2 November 2022, I conducted a compliance inspection via Hanson and saw that no permits had been applied for or issued for the structure. As of 20 December 2022, the property remains in violation with no permits issued. Building Assistant Director Jeff Atkins.
Yeah, any construction on that property of that nature is exhibited in those photos would require a building permit and extensive inspection.
Yeah, I'd hope so. Are we talking about, I just want to make sure because is it the entire?
It's the addition on the back of the home.
Okay,
Yes,
and
sir.
is the addition the blue or the white?
The one that's furthest back. I'm
It looks
colorblind.
I'm-
Yeah,
Okay,
I'm
all right.
colorblind, I apologize.
Are you colorblind?
Yes.
Really? It's interesting. So Okay, and then I'll just say for the record that things like Hansen screenshots are hearsay, which are admissible in quasi-judicial hearings. They can be used. I say this also for the Parks and Rec people who may or may not be here, but it may be relevant for everybody. Using hearsay evidence is totally fine in a quasi-judicial proceeding, but generally speaking, it can't be used alone to support the main findings of fact. There has to be some other basis for it. So I don't know what's going to happen later, but I'm just putting that on the record. There's no problem with it here. So what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, I adopt the county's proposed findings of fact. I find that the property is in violation. I'll grant the property owner 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a fine of $50 per day will be imposed. It will end up constituting a lien on the real or personal property of the owner, which may be recorded as a lien 3 months from, it may be recorded as a lien, may be foreclosed upon, and any other fees and costs as required by county law would be assessed. Thank you.
Next case on today's agenda, Felix M. and Marissa Hernandez, case number 217-4496, Code Officer Brandon Norman. Page 20 of your agenda. Expert on the case, Jeffrey Atkin.
Hello again.
Hey.
Brandon Norman, Citrus County Code Compliance Officer. This is going to be case number 217-4496, construction or modification of a structure without required permits, a violation of Chapter 18, Article 1, Section 18-8A of the Citrus County Code of Ordinances. The address is 5170 South Whippopocket Drive, Floral City, Florida, 34436. The property owners are Hernandez Felix and Hernandez Marissa. I have good service via posted at property and Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is going to be photos taken during an initial inspection on October 12th, 2022. Photos taken at my compliance inspection on November 18th, 2022. And photos taken at my final inspection on December 20th, 2022. Exhibit B will be a copy of the notice of violation, copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who's going to want to be heard on this case?
Windows, carport.
Okay, let the record reflect there is no response. Thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On October 12th, 2022, an initial inspection was conducted of the property for a new front door, a roof over, a RV carport, and vinyl siding on the home of 5170 South Whippopocket Drive in Floral City. Research was conducted in Hanson and was determined that no permit has been applied for. On November 9th, 2022, I conducted a compliance inspection and found the roof to remain, I'm sorry, not the roof, but the modifications, the roof over, to remain without proper permits. On December 20th, 2022, the modifications and structures remain. No permits have been issued. I did speak with the property owners. I checked Hanson yesterday after my compliance inspection. It shows that it has been applied for. But that's just, it's been applied for. It's only been like a day, so.
Okay. So you're representing that they're trying.
They are trying, yes, sir.
Okay.
They've been in contact with me. They understand what the violation is, and they understand what the process is to abate it.
They didn't threaten you.
Unfortunately, no.
Unfortunately, yeah. You look forward to that. Okay.
Those are my favorites, sir.
Does anyone else wish to testify from the county, or?
If there is a permit recently processed, then it would have to go to, until I actually review the permit application. I couldn't attest to whether they've applied for all the violations or not.
I just don't want to not give you an opportunity to speak. You know, you waited, so, all right, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they are advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
And remind me, it's the gate, the front door, and
So it's the vinyl siding that's on
the
the
vinyl
house,
siding.
the door, the roof over. There's also an RV carport.
The
that I
roof
viewed.
over, that front kind
That
of.
front awning,
Okay.
yes, sir. And then the RV carport that's in the rear that I was able to view.
Do you have any, based on visual inspection or other information, do you have immediate concerns, like that you're going to issue some kind of vacate order or anything like that?
Not from my inspection, no, sir.
In this particular case, all those items can be readily inspected once documentation is received, so there would be no.
Are you going to need engineering
It really depends on the carport.
on the carport? Okay.
And the roof over and the RV port in the back.
Okay. I just don't want to set them up to fail with 30 or 60 days if it's going to
I
require
would
engineering.
recommend 120 days to go through the process
Okay.
and allow for review.
That's what I'm going to do. I adopt the county's proposed findings of fact. I find that the property is in violation. I'll grant 120 days to abate the violation. If the violation is not brought into compliance as ordered, did you give me a recommendation?
I did, sir.
Okay. Was it $50?
It was, sir. Yes,
Okay.
sir. $50 a day.
Then a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the property owner will be responsible to pay any other costs required by law.
Thank you, sir.
Thanks.
Next case is on the agenda, Michael Harrington and Laura Elrod. Case numbers 2175359 and 2175360. Code Officer Amy Becker, pages 17 and 18 of your agenda.
No 19?
Oh, and 19,
Okay.
sorry. Case number 2175361. Thank you.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your names.
Michael Harrington.
Thank you.
Thank you.
Amy Becker, Citrus County Code Compliance Officer, case number 2175360, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. Case number 2175361, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Case number 2175359, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 200 South Otis Avenue, Lecanto, Florida. The property owners are Michael Harrington and Laura Elrod. I have good service on all 3 cases via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence for all 3 cases. Photos taken during my initial inspection on October 25th, 2022. Photos taken on October 28th, 2022. Photos taken on November 15th at my corrective action inspection. And photos taken on my final inspection, December 20th, 2022.
All right, ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you,
So this is for the junk. Right.
and just let me know if you have any objection to them being evidence.
Say that again?
Exhibit B.
Oh, Exhibit B, I'm so sorry. Thank you, sorry about that. Exhibit B for all 3 cases, a copy of the notice of violations, a copy of the notice of hearings, and a copy of the signed certified mail return receipt, signed for on 11/19/2022. Thank you.
You're welcome.
the lawn, and then this is the vehicle. This is the junk.
You know, I'm gonna recess this hearing for just a moment because the time is 11:46, and I want to ask a question of the attorneys that's not related to this direct hearing. The time is 11:47. It's just no one's told me. I don't have a copy of that. But anyways, do you guys have an objection to the documents that were shown to you?
No, sir.
Okay. Thank you for your patience. I don't know how they're going to get to me.
30 days,
but...
everything will be done.
Okay. Well, that'll make things easier. Let me first admit these documents as evidence, and let me look at them before you confess to everything.
Junk lawn.
Oh, we know it's there.
Okay. All right, let me just have a moment, Ms. Becker, and we may be able to cut to the chase based on what they've said.
The vessel, we're not going to re-register it. I'm going to have it removed completely.
Okay, I understand that. Okay, I understand that. Okay, so it sounds like you already know what Ms. Becker's going to say. I have to ask for the record, are you conceding that you have overgrown lawn in excess of 18 inches in violation of Code Section 20-61?
Yes.
Okay. Do you concede that you have an unlicensed or inoperable vehicle, which I guess is the boat shown in Exhibit A in case number 217-5360?
Yes.
And do you concede that you have junkyard conditions, which is really just kind of debris that's kind of kept along the side of the house and otherwise in violation of, what is it, Code Section 20-31?
Article 3, Section 20-31A. And my concern is, this is a health hazard. This is piles and piles of household garbage.
Mm-hmm.
This is more than this is this is a concern for health.
Well, let me ask, so do you concede that you have the debris there in
Yes.
violation of the code section?
I'm on disability. He hasn't been able to work. I had
Yeah.
to go through a review. I haven't had my check. I have access to a trailer now, so
Mhm.
when I get my check, within the next couple of weeks, I can take everything to the dump and get trash pickup, and we'll be.
This will be completely corrected.
Okay. Now, when the county brings up a health and sanitary concern, then the issue is that it may require some kind of emergency relief. So, Ms. Becker,
And health department has been out. And they've given us, I think, till the 21 days.
to clear the
Yes.
property.
Yes, we talked to them.
Okay. Ms. Becker, what's your recommendation?
My recommendation on the abandoned, unserviceable, and unlicensed vehicle, case 2175360, and case 2175361, excessive growth and accumulation. The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per case, along with administrative costs, to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for re-inspections. In case 2175359, the accumulation of junk and debris, the Citrus County Code Compliance Division respectfully requests the special master assess a fine of $150 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for re-inspection.
I got all that. I am just looking at something. Well, maybe I can ask the attorneys. Unless there's a finding of a health and sanitary danger, am I required to give at least 30 days? Or is it just whatever reasonable time period? There is no.
Period.
So that's just become a standard. That's going to change. All right. How much time do you need to fix I think you said 30 days earlier.
Yes.
To fix everything?
Yes.
Okay. But you said that the health department has given you 21
Yes.
days on the health.
Yeah.
Okay. All right.
Yeah, it should be taken care of by the 28th when she gets her checklist.
Okay.
The sanitation part will be completely cleaned out by the 28th.
Okay. That sounds good. So what I will do is I will adopt the county's proposed findings of fact. And in case numbers 217-5360 and 217-5361, I'll grant 30 days from today to abate the violation. And if the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. In case number 217-5359, I'll grant 21 days from today to abate the violation to match the Department of Health. If the violation is not brought into compliance as ordered, a penalty of $150 per day will be imposed. This fine will be recorded and will constitute a lien on your real or personal property. This goes for all the cases. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and you would be responsible to pay all costs required by county law. Thank you.
Thank you.
Next case on the day's agenda, John A. Andrews III, case number 217-2833, Code Officer Brandon Norman, page 6 of your agenda.
Hello again.
Hey.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-2833, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 2061 of the Citrus County Code of Ordinances. This is for address 935 South Brisson Terrace, Inverness, Florida 34452. Property owner listed as Andrews John A. III. I have good service posted at the property and Lecanto Government Building. And I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is going to be photos taken during the initial inspection on September 13th, 2022, and corrective action inspection on October 13th, 2022, and photos of my final inspection on December 20th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the continuation letter, a copy of the posting affidavit I completed, and then lastly, the photos I posted of the notice of hearing.
Is there anyone from the public who wishes to be heard on this case? Okay. I'll call you up when it's your, and you can feel free to get ready. Doesn't look like anyone else is shown, so. Without objection, what's been proposed as exhibits A and B are evidence.
On September 13th, 2022, an initial inspection was conducted of the property for overgrown lawn. The property was found to be in violation of the above ordinance. The property remained in violation at my notice of violation corrective action inspection on October 13th, 2022, as well as my pre-hearing inspection conducted December 20th, 2022. I was unable to make contact with the property owner. I did get in contact with his dad at one point, who gave me contact information for him. I still was unable to, I left voicemails, tried to reach out, still got no word back, so.
Okay. Ma'am, would you like to come up and get sworn and give me your feedback on this? You've been patient.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Can you please state your name?
My name is Helen Nordjean.
Cool. Well, what do you have to tell me?
I live on 1041 South Brisson Terrace. It's the last one on the Little Eastman. And I used to own the 935 South Brisson Terrace, and I sold it. I wish I didn't, but anyway. I didn't know what was going on. I thought it was the lady and the husband was going to live there. And then I found out after we did the closing, the son was going to live there. So it was fine. Since the day he moved in but 2 months later, it was little things going on that I thought, would be a little problems. At one point, it was really bad. I even suggest my neighbor, he does my lawn because it's a big property, and mine is as well. And he said, no, I'll do it myself. So and I had to talk to him the most of the time. A lot of times he didn't even answer the phone. He was right there. He never came out. So anyway, to make a long story short, it came to a point, and when I went to get the mail, and the father was there. And I didn't know it was the father. Somebody was there outside, and I said, hello, how are you?
When the people actually bought the property from you.
Yes.
Yeah.
And no, it was the father, the mother bought the property with the husband. They divorced.
Oh,
Yeah,
okay.
and yes, I find out.
Yeah.
Anyway, so he told me that he came to pick up his son because he has to take him to rehab. I didn't know what was going on because I said to him, I haven't seen him in a long time. So he says, I'm not allowed to go into the house, but I'm waiting to pick him up and take him down. So I think someplace in Hillsborough County, someplace. Anyway, so then he came, he came out, he didn't look very good, the young man. So anyway, the long story is then the father came back. So he came to the door to approach me and asked me if it's okay to do charity for me, to give charity so I can feed the cat. I said, I don't need that. I said, I do charity work. Yeah. So I said, I don't need that. I can feed the cat. That's no problem. And I hope your son is going to be okay and everything. He gave me his phone number. He gave me a letter. I have everything anyway. And the phone numbers. And I had the phone numbers of the son, but I didn't have the cell number for the mother. I had the home number, actually, because we did the closing and everything. So anyway, but 10 days later, the car was moved. So I said, I hope nothing is wrong. Nobody, had the courtesy to call me or to say anything to me. Then the father asked me if I can ask my neighbor to do the lawn. So I asked my neighbor, he did the lawn. To make a long story short, it was pots and pans everywhere. So he went up $250. He gave him $250. And then he spent $150 to fix his motor. So he says, I'm not going to do anything anymore in this place. So anyway. So I called him and told the father, like Brendan mentioned, and he was very nice. And then when I called him and said to him, they moved the car, everything's okay. He says, yeah, everything's okay. And I said, I haven't seen the cat. He says, oh, the cat died. I said, excuse me? And I'm feeding the animals, I guess. And they didn't have the courtesy to even say anything.
It's really weird.
I called them a lot of times. They never replied back.
Okay.
So I came here because it was getting to the point where everything was growing, and I don't want to be afraid to go home, sir. I'm alone, and I don't want to be afraid home. Sometimes I go home 2 in the morning, 3 in the morning. Depends on, and sometimes I have to leave 2 in the morning, or it depends on the things I do.
You're out late partying and
I do charity work.
3 a.m.
No, but I'm just charity work, and I don't want to be afraid to go home or
I
to
understand.
leave my house.
I understand.
I'm there since '97.
Right.
I'm not, just came in there. And anyway, so what happened is everything was growing. So I came and I asked what it's all about. What I should do if I do the complaint, whatever. And they told me what's involved. And I said, okay, let me try to call them again, and then I'll come back. So I tried, and I talked to the father. They told him not to be involved anymore. So I said, okay, how am I going to get in touch with them? They don't even answer the phone and everything. Everything is growing, and I have to do. He says, well, you have to do whatever you have to do. So then it came a little time because I was out of state twice, doing charity work again. So I came home, and it was really bad. So I came and did the complaint. So then Brendan comes along because he actually with they told me somebody's going to be there a certain time. Then I find out it was, and I called, and he called me back. He was very nice to call me back and everything. And he explained things to me. But in the meantime, it took, I don't see anything happening. And one time I came home, and it was a little early, thank God. And this big branch was right by the mailboxes, and so I got my neighbor, so we pushed it back, and it's right there. You can see it. I'm not lying or anything. So. And then it came to the point I needed to know that I'm safe, because 3 times I had to put my alarm on to open my gate. And I don't think that's very nice because you can't see anything anymore. Okay. And I don't want to be afraid to go home, sir. Yeah. And nobody can, because even Brendan told me, you might give him another month, you might give him another time. I said, no, they don't need no more time. I think they should do something. Because, you know, I can't be afraid to go home, sir.
Yeah.
Nobody says that, and nobody, it's written anywhere that we should be afraid to go home. No. I'm
Well-
sorry. That's why I'm upset, actually, because I don't want to be afraid to go home.
Well, I mean, that makes perfect sense. So what do you want me to take away from this? That I mean, this is an overgrown, you know, grass case, right? So
The
what I
grass
can.
only, we have rats. You know what happened?
Okay, so that's important. So
We have
I didn't
rats.
hear that. So
No, but the thing is, I'm sorry I didn't say, but you know, it was the, I guess one of the, I make the place so beautiful and now it looks crappy.
Right.
And I'm sorry to say that, but one time, you know, the porch, it's full of bags, black bags with garbage. I didn't know, but what happened is, when he was doing the lawn, the door opened up. You know, I guess one of the bags fell and the door wasn't locked on the porch. And the bag was there. He looked up and said to me, "Don't look inside."
okay.
And then he told me, you know, that he hit all the, you know, this rat thing that's all over. And now I see them. And
Well, no, that's relevant.
and I mean, it's terrible. I mean.
So, Mr. Norman,
I
are you
don't know.
aware of the rat issue?
I was not aware of the rat
Okay.
issue, sir. I also have been very
I can
limited.
point it out if you want.
No, it's fine.
I'm very limited on my inspection area too. It's essentially an easement that goes into their property and then into her property. But there's a gate right there, and it has a posted no trespassing sign. So that's where I have to do my inspection.
No, I
unfortunately.
understand.
So,
I took them out, actually.
Okay.
But yes, I was told to take it out because they left the package at the end. Somebody took it from my package, actually, because they couldn't see the way to come in all the way down to my. It's an easement. The road.
easement.
It's an easement.
Yeah.
And with four owners, so we're supposed to be responsible for all that. And they
Yes.
have on the deed. Everyone has on the deed. There have to be clearance for me to go home and get out. 15
I
feet.
understand how it works.
Okay, but and it's not happening. So
What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and respondents' actions relative to this violation. We would also ask that the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Yeah, it's really not a hard. Actually, how big is the lot? Do you know? You said it's big.
It's 2 acres.
2 acres.
Yeah,
That is
and
big.
I have 2.5, and I'm on the
Yeah.
back, and it's the water in the back.
Well, 2 acres is substantial.
May I add something to it? I'm sorry to interrupt.
Okay, we're about at the end. Go ahead.
No, but just want to make sure, you know, I had to go I left here, I have to go to the sheriff's office and to the commissioner's office. And the commissioner, it was very nice. Anyway, and they told me what, you know, was going on and everything. And then I had to go to the authorities because if something happens to me in the middle of the night, nobody's there.
Right.
And I can be dying right there, you know, just try to open my gate. And so, just so they know what's going on, so they have
Oh,
a
yeah.
report and everything. So they have a report, and everything.
Oh, I appreciate you letting us know that. I think, gosh, I mean, 2 acres is a substantial size. That affects, you know, how much time I have to give. On the other hand, there's rats. So here's what I'm going to do. I'll find that the property is in violation. I'll give the owner 14 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $150 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Andrews. The basis for the timing and the fine, timing is my own determination. The fine is above what was recommended, is based on the health and sanitary issues raised by a member of the public. You know, anytime you have rats involved, that's just the smoke where there's fire. So,
I took pit bulls one day.
yeah, but I mean, you know, anyways, this fine will be recorded and will constitute a lien on the real personal property of Mr. Andrews. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner will be responsible to pay all costs required by county law. Thank you.
Thank you, sir.
Thanks.
Thank you so much for your time.
Next case on today's agenda, John F. Boyd, case number 217-3965, Code Officer Brandon Norman, expert on the case, Jeff Atkins. That's page 7 of our agenda.
Thanks.
Can't remember if I said it.
Okay, hello again. Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-3965, construction or modification of a structure without required permits, a violation of Chapter 18, Article 1, Section 18-8A of the Citrus County Code of Ordinances. Address in question is 5060 South Pheasant Way, Floral City, Florida, 34436. Property owner is Boyd John F. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is going to be photos taken during the initial inspection on October 5th, 2022, photos taken at my compliance inspection on November 9th, 2022, and photos taken at my final inspection on December 20th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response. Oh, okay, thanks. Without objection, what's been proposed as exhibits A and B are evidence.
On October 5th, 2022, an initial inspection was conducted of the property for a new roof of the home at 5060 South Pheasant Way in Floral City. Research was conducted in Hanson and was determined that no permit had been applied for. On November 9th, 2022, I conducted a compliance inspection and found the roof to remain without a permit. On December 20th, 2022, the roof still remains and no permits have been issued. There was a permit applied for on the 1st of December, but again, it's just applied for, and that's where it's at right now.
And it's applied for the roof.
Applied for the roof, yes, sir.
Okay. Is there anyone else who wishes to testify from the county?
Sir, Jeffrey Atkins, Assistant Building Official. I reviewed this permit application. In fact, I personally did the plan review for this application. The permit application was for an after-the-fact metal over metal roof. This permit application has been denied for further information. Given the type and age of that particular mobile home, a standard roof over would not be sufficient. After reviewing those photos, that will require an engineered roof assembly over that particular mobile home with engineering to assess the structural integrity of that mobile home to support said roof structure. In further review of those photographs, it appears that there are potentially other renovations being undertaken there. There is what appears to be a shower surround, bathroom exhaust fan, and what appears to possibly be drywall material. That in itself would not be permitted in a mobile home of that age. It's required to have like-for-like materials.
Like-for-like materials, meaning they can't upgrade per se?
With engineering.
Okay.
The key is the chassis and suspension when the mobile home was originally manufactured was established for a certain weight.
I see.
And whenever you add other materials, taking paneling out and putting in sheetrock, that requires engineering.
Okay, that makes sense to me. Okay, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow her for reinspection.
How long does this you said engineering on a roof, that could take a while.
The applicant has received the comments and is aware of that. Yes, it will require engineering. 90 to 120 days is not unusual for that type of.
Do you have concerns that the structure could fall under the weight of the roof, or is okay? No. All right. Then I find the property in violation. The property owner is granted 120 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the property of Mr. Boyd. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Mr. Boyd shall be responsible to pay all costs required by county law.
Thank you, sir.
Next case on today's agenda, Scott F. Carrig, case number 217-6331, Code Officer Amy Becker, page 9 of your agenda.
Amy Becker, Code Compliance Officer. This is case number 217-6331, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 68 South Columbus Street, Beverly Hills, Florida. The property owner is Scott F. Carrig. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on November 4th, 2022. Photos taken on November 29th at my corrective action inspection. Photos taken on December 1st, showing the posting of the property. And photos taken on my final inspection, December 20th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is none. Without objection, what's been proposed as Exhibits A and B are evidence.
On November 4th, 2022, I conducted my initial inspection for excessive growth and accumulation of vegetation and observed grass in excess of 18 inches in the backyard, which is a clear violation of the ordinance listed above. As of my final inspection on December 20th, the backyard remains in violation. I have not had contact with the owner.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with administrative costs, begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The owner is granted 14 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. And I hereby incorporate other standard provisions to the order regarding foreclosure and other costs.
Next case on today's agenda, Barbara Chamness, case number 217-71567, case number, page 10 of your agenda, Code Officer Cody McGuire.
Which case is this?
217-1567.
Page 10.
It says
Page 10.
Mr. Hampton on my...
Yeah.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
Good morning.
Good morning. Or afternoon.
Yeah, shoot, you're right.
All right, my name's Cody McGuire, Citrus County Code Enforcement, case number 217-1567, accumulation of junk and debris, a violation, Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinance. Address 6075 South Ludinger Drive, Homosassa. Property owner Barbara Chamness. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos were taken during my initial inspection on August 25th, 2022, and a corrective action inspection on October 11th. And
I just want to be clear, you said it was your inspection, but Mr. Hampton was listed here, so is it yours or his?
No, it's his.
Okay. All right.
Did I say hi?
I thought you said my, so I just want to... I don't know where
No,
to
I would like
change.
to authenticate the following documents.
It's not what I heard, but okay.
Oh, okay.
That's
I can start over.
No, it's fine.
Okay. Photos were taken during the initial inspection on October 25th, 2022, and a corrective action inspection on October 11th, and a final inspection on December 20th, 2022. Exhibit B, a copy of notice violation and a copy of notice of hearing, a copy of the photos taken and posted property, a copy of the posting affidavit Co-Director J.C. Charlton completed. An inspection was conducted on... Do I show pictures?
Well, so at this point, normally I think what happens is we'd show it if they were here. They're not here, so you might want to show the attorneys because I'll want to review them as you go into the case. Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. All right, thank you. We're good. Without objection, what's been proposed as exhibits A and B are evidence. You can proceed.
An inspection was conducted on August 25th, 2022 by a previous code officer for junkyard conditions. There is discarded furniture, trash, toilet, automotive parts, cans, and empty buckets. Director J.C. Charlton posted the property on December 8th, 2022. I conducted a pre-hearing inspection on December 20th, 2022 and observed the property to continue to be in violation. The photos
Have you had contact with the property owner?
No. Barbara called the office and did speak with JC though.
Okay.
Yes. She spoke with me. She stated that she's.
Have you been sworn in?
Yes.
Okay.
Well, not for this case, but earlier.
Well, you were earlier sworn in. I mean, not that I really don't worry about it, but yeah.
Yeah, she called the office and I spoke with her about the case and explained the violation. She just has been unable to abate it by the time of our hearing.
Do you know if she had contact with Mr. Hampton?
I do not know.
Okay. Did she indicate a willingness to cooperate and get it done?
She did.
Okay. What's the county's recommendation?
The Citrus County Code and Compliance Division respectfully requests that the special master assesses a fine of $50 per day along with administration costs to begin after the date you deem sufficient to abate the violation. The amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given to the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated or order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. Grant the owner 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the owner's property, and I incorporate the other standard cost provisions.
Next case on the day's agenda, Teresa Diane Collis, case number 217-4225. Officer assigned to the case, Cody McGuire, page 11 of your agenda.
Cody McGuire, Citrus County Code Enforcement Officer, case number 217-4225, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 2061 of the Citrus County Code of Ordinance, address 909 North Crystal Crest Terrace. Property owner Teresa Diane Collis, good service posting the property at the Lecanto Government Building, or in at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence.
Cody, you have to stay with the law.
what
Yeah,
they are.
so you're gonna seek to introduce exhibits A and B into evidence. So what are they?
Exhibits. Photos taken.
Photos taken.
Yes. Exhibit A, photos taken during my inspection on October 7th, 2022, and corrective action inspection on November 22nd, and photos of my final inspection on December 20th, 2022.
And what is exhibit B?
Exhibit B is a copy of the notice violation, a copy of the notice of hearing, posting affidavit, photo, and the posting of the property and at the Lecanto Government Building.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response. I don't, thank you. Thanks. Without objection, what's been proposed as exhibits A and B are evidence. I will say that if supposedly there's another hearing notice to start at 1 o'clock, that I'll need to recess this in about 15 minutes, just so that I can survive. So anyways, all right.
I'll continue. On October 7, 2022, my initial inspection was conducted at the property located at 909 North Crystal Crest Terrace for overgrown lawn. The property was found to be in violation of the above ordinance, and notice of violation was issued. The corrective action inspection was completed on November 22nd, and the property was still in violation. A notice of hearing was issued for today's hearing. As of my final inspection on December 20th, the property remains in violation.
So your evidence looks pretty good. I see that you used a stick to measure the 18 inches.
Yes, sir.
But it's not like a measuring stick. It's just a stick with a line that says 18 on it.
Correct.
How did you determine that that was 18 inches?
I used the measuring tape to mark.
So you created that stick yourself?
Yes.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate the violation. The amount was selected based on the actions of the property owners once they were advised of the violation. The amount is appropriative to or given to the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 14 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the property of the owner. Thank you.
Next case, Brenda J. Graves and Angelica B. Hart, case number 217-3469, Code Officer Brandon Norman, page 15 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-3469, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 2041 of the Citrus County Code of Ordinances. Address is at 10242 East Pike Drive, Inverness, Florida 34450. Property owner is listed Graves Brenda J., Hart Angelica B. I have good service via certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on September 22nd, 2022. Photos taken at my compliance inspection on November 9th, 2022. And photos taken at my final inspection on December 20th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wishes to be heard on this? Let the record reflect there is no response. Okay, without objection, what's been proposed as exhibits A and B are evidence. The county has 90 seconds left to finish
Here we
this
go.
case.
I'll talk as fast as I can. On September 22nd, 2022, an initial inspection was conducted of the property for unlicensed vehicles at 10 242 East Pike Drive in Inverness. The property was found to be in violation of the above ordinance. On November 9th, 2022, I conducted a compliance inspection and found a vehicle with no tag in addition to the one observed at my initial inspection. On December 20th, 2022, I observed no change. I've had no contact with the property owners.
County's recommendation.
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
It's 2 cars that are violating, correct?
It was initially one. So I was there initially for junk, debris, overgrown lawn. Those abated. The vehicle never did. And then on my compliance inspection, the second vehicle showed up and I was like, okay.
And that's what I mean. In order to abate this, it's 2, right?
It's 2 now, yeah.
Okay, all right.
Yeah.
Property's found in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed based on it. There's actually 2 things that need to be abated for this violation to go away.
Yes, sir.
This fine will be recorded and will constitute a lien on the real or personal property of the owners, and I incorporate the other standard provisions regarding costs.
Thank you, sir.
Yep.
Is that 90 seconds?
No, we have to do better.
Next case, Deneen Hafke, case number 217-3575, Code Officer Brandon Norman, page 16 of your agenda.
Move that to.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-3575, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 2031A of the Citrus County Code of Ordinances. Address is 5666 South Pendant Point, Floral City, Florida, 34436. The owner, I'm going to butcher this, it's Hafke Deneen. Good service, signed via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during the initial inspection on September 26, 2022, and corrective action inspection on November 4th, 2022, and photos of my final inspection on December 20th, 2022. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail return receipt.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. County Attorney's Office is going to look these exhibits over, make sure that they're good. Without objection, what's been proposed as Exhibits A and B are evidence.
On September 26, 2022, an initial inspection was conducted at the property for junk. The property was found to be a violation of the above ordinance. The property remained in violation at my notice of violation corrective action inspection on November 4th, 2022, as well as my pre-hearing inspection conducted on December 20th, 2022. I was able to make contact with the property owner. She does not live here. She is the landlord. She has stated that she's in the process of evicting the tenants. Mm-hmm. She has a cleaning company supposedly on standby ready to clean the property, but the tenants will not be evicted until the first of the year. That's when they're ordered to their eviction notices for, she said.
Yeah. There's a lot of leases where landlords preserve the ability to go in, but all right, what's the county's recommendation?
The Citrus County Code of Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I find the property in violation. The owner is granted 90 days from today to abate the violation based on the representation regarding eviction. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Deneen Hafke, and I incorporate other standard cost provisions to the order.
Thank you, sir.
Next case is Michael Howie, case number 217-4885 and 217-4743, Code Officer Amy Becker, pages 21 and 22 of your agenda.
Amy Becker, Co-Compliance Officer, case number 2174885, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61, and case number 2174743, accumulation of junk and debris, a violation of the Code of Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 90 South Lincoln Avenue, Beverly Hills, Florida. The property owner is Michael Howie. I have good service via posting of the property, as well as a signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. On both cases, Exhibit A, photos taken during my initial inspection on October 18th, 2022. Photos taken on November 2nd at my corrective action inspection. Photos taken on November 17th. Showing the posting of the properties, and photos taken on my final inspection December 20th.
Is there anyone from the public who wishes to be heard on this case?
Exhibit B.
She says you don't have an Exhibit B.
Oh.
Let the record reflect that there's no one from the public to speak on this case.
Exhibit B, I apologize. For both cases, Exhibit B, a copy of the notice of violations, a copy of the notice of hearings, and a copy of the posting affidavits, and a copy of the signed certified mail return receipt, signed for on November 14th, 2022.
Okay. What's the county's recommendation?
The county's recommendation on...
Wait, I'm sorry. Without objection, what's been proposed as Exhibits A and B in each case are admitted as evidence. Thank you. That's the county's recommendation.
The county's recommendation on both cases, case 2174885 and 2174743, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per case, along with administrative costs to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violations. This amount is appropriate given the severity of the violations and the respondents' actions relative to these violations. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for re-inspections.
All right. I adopt the county's proposed findings of fact. In each case, the property is found in violation. In each case, I'll grant 60 days from today to abate the violation in each case. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This applies to each case. And in each case, the fine would be recorded and constitute a lien on the real or personal property of Mr. Howie. And I incorporate standard cost provisions.
Next case, Lawfully Enterprises, Inc., case number 2174571, Code Officer Cody McGuire, page 24 of your agenda.
Thank you.
You're welcome. Cody McGuire, Citrus County Code Compliance Officer, case number 2174571, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinance. Address 8781 West Arbor Court, Homosassa. Property owner Lawfully Enterprises, Inc. Good service signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on October 13th and a corrective action inspection on October 27th. The photos of my final inspection on December 20th. And Exhibit B, a copy of the notice of violation sent to the property owner and registered agent, a copy of the notice of hearing sent to the property owner and registered agent, and a copy of the signed certified mail return receipt in Sunbiz business summary page.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is not. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence. I find it compelling.
Keep going?
Yeah.
Okay. On October 13th, 2022, an initial inspection was conducted at the property for overgrown lawn. The property was found to be in violation of the above ordinance. The property remained in violation at my notice of violation corrective action inspection on October 27th, 2022, as well as my final inspection conducted on December 20th, 2022. I have had contact with the property owner by phone, and she was not so pleasant to talk to.
What do you mean by that?
Well, she stated she was going to see me in court.
And did you said the owner, but the owner's a corporation. So is she the president of the company? Is she a shareholder? Do you know? I mean, how do you know she's the owner?
I don't.
Is she listed on Sunbiz? Do you have the Sunbiz
I do.
information? Let's see. Not getting good reception here, but.
Do you have your Sunbiz report?
Should be in there.
Oh, it's in here.
Yeah, it should
Oh,
be
really?
part of the
Okay.
exhibits.
Let me check that. Ah, good. Was it Danielle Laughley?
Yes.
Okay, you spoke with Danielle Laughley.
Yes, sir.
Okay, she's represented as the president of the corporation, which, you know, certainly usually presidents have authority to speak. The mailing address in Ocala, Florida.
Yes, sir.
Well, tell me a little bit more about the phone call. I mean, you called up out of the blue, right? And you explained the violation?
Yes. When I explained the violation, she said that she had paid the fine previously, and someone had told her that basically anything that was on that property would be abated.
Was there another case on this property?
Yes, sir. I have liens against the storage on a vacant.
It's on the same property?
Yes, sir.
Okay. And so you told her there was a new violation. She doesn't think they're responsible, or
All in all, yeah. She and her verbiage was, I've already had this cleared and taken care of, and that was whenever she.
Is she aware that grass grows?
I'm not sure.
Like it can come back.
Yes,
You know?
we are.
Yeah.
But I can't speak on behalf of her.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assesses a fine of $50 per day along with administration costs to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master additionally find that the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
If this is a repeat violation, why isn't there?
It's a different
It's a
violation.
different.
Yeah, this
oh,
one's
okay, it was a
for
different
lawn.
violation. What was the other violation?
Storage on a vacant.
Which they appear to have right now.
The trailer, correct.
Is that case pending?
There's liens.
It's never abated.
Oh, it never abated.
Yes.
Okay. Adopt the county's proposed findings of fact. The owner is granted 10 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $300 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Laughley Enterprises, Inc. I'm deviating from the county's recommendation due to the willful failure to maintain the property, the willful failure to cooperate with the county, and the fact that there is still a pending unabated violation on the property. So fine will be recorded and constitute a lien on the real or personal property of the company. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record and other standard cost provisions. Thank you.
Next case is on. Sorry.
I've got to adjourn.
Okay.
I know that there's only, I think, two more.
Three.
Three? Oh, but, well,
Well,
two sets. So what I'd like to do is come back at 1, and if people show up, we handle those. If it's even proper, but if not, then I'll want to finish your cases. I don't know how many people will show. I don't know. I don't have an agenda. I don't have anything, so I can't tell you. But
She has one for you out there. They're here already.
Oh, people are here?
No, not people, but Francine with
Parks and Rec.
Parks and Recs
well,
are here.
I know it's an
Actually,
imposition on y'all, but because that's noticed for 1 o'clock, I have to do it at 1. If if it had been noticed for directly after code compliance, then I wouldn't have to do this. But
Do you want to
Can
continue
we
those three?
continue the last three
I mean,
till
it's-
next?
oh, it's up to
month?
you. Do you want to move to continue them? I mean, I don't see. It's
It's only 3.
It's up to you if you want to continue them.
Because you're gonna have to review the letter.
I say let's continue. I mean, they're.
I mean, are there any serious issues or?
No.
To grass and junk and debris, right?
Right.
Yeah.
Nah,
So we would take it up after. I mean, or we could just take it up after the next.
That's fine.
I want to continue. But I don't have a say.
You have to renotice everything.
Look, I mean, you better let me know now because I'm adjourning.
Continue.
You want to continue
We'll
them?
continue.
Okay, then before we adjourn, what I'll do is I'm going to go ahead and continue case numbers 217-2930, 217-2929, 217-6447 to the January 2023 code compliance hearing. Okay? The time is about 12:44, and we'll be back at 1. Or no, this hearing's totally adjourned. I'll see y'all later. Thank you.